To you by adminmonitor.com will begin momentarily. Thank you for your patience.
As I was joking earlier, it's not much to talk about today, so I'm sure it's going to go real fast. But what I'm normally bad at, I'm going to start out today, and we'll make introductions around the room. I'm John George, co-chair on the attorney side of the Broker Lawyer Committee. And start with the Zoom, we have Chairman Scott Kesner. He's one of our committee liaisons, and very much appreciate all the time that you give our committee, everything you do for us. We have Lee York.
Good morning.
And then let's see, we have on the side there,
Commissioner
Hartgrace is one of our committee liaisons. We appreciate all your assistance on this committee and being here today. Do we have and then we have Commissioner Harvey Lowe. It must be one of the numbers that called in there. Thank you, Commissioner Lowe, for attending. Then if we go around the room, if you can briefly introduce yourself.
Waitress Hall. See you guys again.
Ron Walker.
Christy Tatum Jansen.
Tony Malley.
Mary Miner. Diane McCoy.
Melissa Haley.
Amy Slusher.
And then we have several guests in the room. In the back here is Fabian Saldana, builder out of Houston. And if you can introduce us as you go.
Lori Lady, General Counsel at Texas Realtors.
David Jones, Deputy General Counsel at Texas Realtors.
Kelsey Vanderveld, Associate Counsel at Texas Realtors.
And Robin Harris, Senior Associate Counsel at Texas Realtors.
Hey.
There I go, sitting in.
Tracy Short. I'm Vanessa Burgos, General Counsel for TREC.
Abby Lee, Deputy General Counsel for TREC.
Chelsea Buchholz, Executive Director.
All right. And we do, SJ was tied up with a matter, but she'll be joining us later by Zoom. So she'll pop in at some point. But we'll jump right in. And the first item on the agenda is a public comment on non-agenda items. And what we wanted to do here is really take the elephant in the room and go ahead and discuss it up front with the commission issue that's hanging out there. Texas Realtors is here today to give us an update and a presentation on some of their suggested changes to the contract. And what I wanted to do to kind of tee it up and not take over what they're going to present, but really just generally explain the issue. And then for anything that needs to be clarified and of course added to your presentation, please let me know. But what we're looking at today is addressing the commission language in the contract. And I think as most people are aware, it's in the news, it's everywhere, and there's a lot of misinformation out there. There's probably what I've seen more bad information than good information. And a lot of the talking heads are not looking at the actual underlying contracts. They're not looking at the language of the settlement agreement. They're not looking at the playing field of all the lawsuits that are out there. And it's a complex issue, and it has a lot of facets, and it's going to take a lot of hard work to figure out how to make this run smoothly, how to make these contracts fit the current situation and what we need to do. But there are several different lawsuits, and everybody hears about the big one in the news that's settled. That's not the only one, but it is one of the larger and of course more well-known ones that settled. The settlements that are out there don't necessarily impact the other lawsuits or the DOJ action that's pending. It tries to address it in certain ways, but when we look at taking action today, and as we go through our discussion, we need to be mindful that there are other possibilities out there that may come down in terms of requirements, of pressure points, of practice changes that we'll have to address and when looking at this language. The DOJ itself has filed interventions in other lawsuits that didn't settle and are making their position a little more drastic than they had taken in the past that we've seen. And we'll likely discuss that today. But one of the big things, I hope everybody that's watching this today and is participating understands that a lot of what we're just reading is misunderstanding. We really have to get to the core of the language and look exactly what's happening. And be mindful that it is not static. This is fluid and it's changing. I know Texas Realtors has been hard at work in developing new forms and addressing these lawsuits. So I'm very excited they're here today to give us the presentation and discuss about the changes that they suggest that we make to the contracts. I have seen a lot. This is a very important issue for many reasons outside the lawsuits, is because these agents and brokers are misusing some of the forms that I've seen. They're trying to do patchwork and attach, registration agreements as addendum and making it, contingent upon that. And all these practices that aren't what the forms are meant for. And I think that the agents themselves and buyers and sellers are not having a good understanding of how they're using or trying to use these forms to cobble together what they think is the current state of the law. And so when we look at it today, our contracts are set up where we have all the contracts with one informational disclosure about commissions. And the only enforceable commission agreement we have is in the farm and ranch. There's one in there between brokers and there's one in there between buyers and sellers. But that's the only form we have that actually has an enforceable agreement. So as we look at it today, we have a couple different views that we'll be looking at it from with the different contracts. And then suggestions are made that it goes the whole scope from us doing nothing to revising the contracts, adding new stuff, to developing a whole new form. And there's different ways to look at it in terms of whether that's talking about compensation, whether that's talking about concessions. There's different ways we can approach it. So I don't want to preempt the discussion, but I kind of wanted to tee up the issue before we just jump right into the presentation. But I think it'd be a good place to start with hearing it from Texas Realtors. If you're okay to present now, we'd love to hear an update and about your suggestions.
Do you want me to just hear? I can just talk.
Yeah, that'd be great. If let us know if you can hear online. If not, we'll move the microphone back.
And I think those two, at least that I can see on the screen, have heard this a few times. Again, I'm Lori Levy, General Counsel at Texas Realtors. First of all, thank you for having us today and allowing us to bring this information to you. You did an amazing job setting up this. We'd love to have you come talk to our members about that. This is probably the biggest change that we've seen. I've been with Realtors for 18 years now, and this is a big deal. The court cases are voluminous. Just to give you a little bit more detail, I don't want to get too far into the weeds on this, so tell me if I've gone too far. But just to give you a little bit more background on that, the DOJ had begun an investigation many years ago of cooperation and putting the requirements to put listings in the MLS as commonly as they're required to do. There's separate litigation going on between DOJ and NAR on that, and last Friday an appellate court did issue an opinion saying that the DOJ did have a right to pull their agreed settlement that they had entered into with NAR, pull that back and begin the investigation again, or widen it, or basically do whatever they want to do. So the DOJ is still out there separately. As John said, they have weighed in on other cases. They have not weighed in on this one, for which we do have a settlement on the table. Could that happen? It could. It makes everything that you're talking about today and everything that we're talking about with our forms tenuous. But at the same time, we have to start moving forward. The changes that are coming are anticipation of that settlement being final, not the other way around. The other thing that I'll preface this with is I have never in my almost 30 years of practicing law, I feel very young, but old, had to operate under a settlement agreement like this. There's no case law. There's nothing to look to other than the words that are in the agreement. And that makes it challenging. How do you interpret those? The attorneys in the room, even the brokers in the room, we all know we can look at words and interpret them very many different ways. So that is also challenging. We are looking at NAR with their updates to their code of ethics and their MLS rules that will be required for MLSs across the country to see what those say. And we don't have that language yet. We have started with a task force of our own. Just so everybody remembers, Texas Realtors does have representation agreements, both the listing agreement and the buyer's representation agreement. We also have registration agreements between brokers and then between an owner and a broker for a FISBO situation. And we have other forms as well that we may be looking at. So we have started that task. We have also begun a conversation about what we need to do legislatively, which you all know will not be till 2025. And so there may be things there in the Real Estate License Act that need to happen. One of our concerns is making that level playing field for all consumers and all license holders across the state with these changes that are coming. So we are studying that, and we'll be working with TREC And I don't have any suggestions yet or even know which way we're going yet, but we'll be working closely with Trek staff on that. So the settlement, this was a case that was brought by home sellers in Missouri. There was a verdict handed down back in October in favor of the home sellers class action certification. It was a very large number in billions of dollars against NAR and all the other defendants. As soon as that happened, copycat cases were filed nationwide, 2 here in Texas in November, one in November, one in December. The 2 Texas cases were consolidated, so it's now 1 case here in Texas. That case is still active. We are included in the settlement agreement as far as the definitions for what the class consists of. It would include the plaintiffs that filed in Texas. It also includes the associations, local realtor associations, Texas realtors, MLSs. If they opt in, there's some opt-in language for some of the parties, but for the most part, members, associations, MLSs, and many of the brokerage defendants are included in this settlement. We all know that doesn't mean there might not be future lawsuits or different lawsuits, but this is a settlement of a massive scale. NAR has agreed to pay $418 million over a 4-year period. At this point, there's no requirement that anybody else pay money toward that, but there are changes to transactions, to commissions that must occur. To talk about that a little bit, the MLSs will be required to update their rules, and this is what we're waiting on NAR to do. NAR meets in May, so we're looking, I think, at May 11th is their board of directors date, and that's what we're looking to see what they come up with to comply with this settlement. Commissions will no longer be allowed on the MLS, so no more unilateral offer of compensation from a listing agent to a buyer's broker. Can't even mention commissions in agent remarks or any field on the MLS. That does not preclude cooperative compensation outside of the MLS. Now, be aware, there is an opinion by the DOJ in a different case where they're not even sure they like cooperative compensation. So we are closely watching to see if the DOJ speaks out on this. They try to intervene in this case, what's going to happen there. But as of yet, they have not said anything to that effect. I think they may be emboldened by the appellate court decision that came out last week that allows them to even open up a separate investigation outside of the settlement. But I know that NAR has been communicating or attempting to communicate with the DOJ on that, but that is still kind of an unknown. The settlement agreement, the expectation is that it would be final at the end of the year. But to get to that point, NAR does have to update the rules for the MLSs. Like I said, that'll be in May. And they have said mid-July for changes. So we're assuming or guessing that it's a May adoption for an implementation sometime in July. So it's a pretty quick time frame here that we're working under. Commissions off of the MLS can be done outside of the MLS. Cannot even use a feed from an MLS to populate commissions. So there's a complete severance of the commissions from the MLS. Our goal is to have forms updated and ready so that when NAR updates their rules, we can have our forms ready for the members to use. I think for your purposes today, it's much more minimal because there's only a few references to commission in the forms, but understanding what your co-chair said, that you guys have the choice of going from one extreme to the other. We are here to provide you input if needed. Happy to share our expertise. We appreciate you looking at this so quickly. I know you already had a full plate, but anything that we can do to help you in your decision making, we're here to do. If I didn't leave anything out of importance from the MLS rules, I'm going to hand it over to Robin to talk about some suggestions that we have provided you in writing. You should have a copy of that, I believe. These are just suggestions. We did put this through our task force last week, which is brokers from around the state, just like you all have here. But hoping this is a starting point for you all to make some considerations.
Yeah, thank you, and thank you everyone for having us. I think this was uploaded yesterday as a supplement to the materials. This is a letter that we submitted last week. Just having looked through the contracts and kind of anticipating how fees would be paid moving forward, and we saw for the most part 3 ways. Either the buyer could just pay their broker directly, There could be cooperative compensation like there currently is, where the seller's broker makes that payment to the buyer's broker directly, or the seller could pay either directly to the buyer's broker. One of the things that the settlement focused on were seller concessions, and so that's one of the things that we thought we could help in the contracts with. But so starting on the second page, there are our first recommendation in paragraph 8. There's a separate paragraph 8B related to brokerage fees being part of a separate written agreement. Not knowing exactly how things are going to be in the future with payments, we thought removing that language from the contract in case those, just trying to anticipate how things will work. Second recommendation, this is where we look at those seller expenses and adding a new line specifying that as part of those sellers' expenses, they will pay X amount of compensation to buyer's broker. At first, we had other broker in there, which is defined on the last page of the contract. But in intermediary situations, there wouldn't be an other broker. It would just be the same broker. So that would be going there. So that was a recommendation. And then in the next part of the paragraph where buyer's expenses are defined, and that includes broker compensation as a buyer expense. The third recommendation, this is where on the last page, which does have the broker information, there's that disclosure related to the separate agreement between the brokers for payment, just removing the reference to the MLS operative compensation and just making it more general in that language. And then another corresponding change in the farm and ranch contract, because as was discussed, that does have specific information related to that compensation to the sellers and buyers brokers. And so having that language added so that it can be by separate agreement outside of the contract, and then also make that change from other broker to buyer broker in the case for intermediary agreements. So that generally concludes our comments. I'm happy to take any questions.
Just two quick questions I thought you could address in this as well, and we can dig deeper into this as well. But one is, with regard to the concession approach, how does that affect any kind of lender situations related to that? And then,
so, yeah, and that's a good question. I can address that. We did just get confirmation yesterday for FHA loans that that would not be considered part of the buyer's funds as far as qualifying for loans. So that would continue to be separate. NAR has sent a letter to the VA to see if they can update their rules to allow some changes to allow to help with the settlement for the other possibilities of compensation to the broker.
so is not to be confusing then, is concession the right word there?
So concession is what is used in the settlement agreement. Concession is not used in our contracts that we have here. Those are separated by seller expenses and buyer expenses. Seller concession is just, I think, the term generally used in the industry.
Okay, and then, because I know with the 6% limit on the concessions that the lenders typically have, what I wanted to do was, I didn't know if that would be confusing if you're saying given one concession and then cause the concession to go up over the limit because of the fees.
Yeah, and part of the issues that we're dealing with is there are so many players in a transaction that are all going to have to be looking at what's coming up, whether it's title, lenders, in addition to brokers. So
Did y'all talk about, since you have the commission agreements expressed in the farm and ranch, if it's good for one form, why not good for all the others?
I think that that's up to the committee. I think that having that information, the important thing is clarity.
Right. Do you have a preference? from the industry.
Yeah.
Do we have a preference?
From the industry.
We don't yet have a
Not yet.
preference.
Okay.
And honestly, our tactic on this was what's the minimal that would need to be done quickly, knowing that that might be a bigger discussion. We have to find out if we have a preference.
Sure. Chairman Kesner has a question too, and then I want to follow up, make sure I don't forget on the concessions versus if there's already an offer that's enforceable between the listing agent and the buyer's broker, and then they put more in concessions, then it's potentially doubling up. But I want to get to Chairman Kesner first here.
Just real quick on the expenses payable by the buyer under 12A2. We talk about MIP and PMI as required by lender. I think after broker compensation, there has to be allowed by lender because, I mean, we had 2,048 people buy a house VA in El Paso. They can't buy it. And if it doesn't say as allowed by lender, I don't think you can make that argument presenting a contract that the purchaser cannot pay that in a VA transaction. And I know VA is supposedly working on it. I will probably be retired before they get something changed at the VA. So if we could just put as allowed by lender, I think it would clarify it. And then to follow up with Ron on the concessions on conventional for an investor, it's only 2%. So there's a lot of play in that. And I know it's early, but that's the one thing I'm worried about in our market is the VA purchaser being unrepresented. And I think as allowed by lender would maybe clarify that.
And I think that's a good point there. And to circle back to this language, the practice, it's left to be seen how the practice will actually change. And if we look at our committee's direction, right, we're to reduce controversy, we're to make things run efficiently and not put our thumb on the scale to any particular side. And so when we're looking at this language, whether it's concessions or commissions, it almost necessarily with what we do can help shift the practice. But the practice itself is going to be changing so much with the new rules and with the number that will be using forms that are not ours, from the industry forms, from either lawyers or from the trade groups or from anybody. The use of those forms and the number of use of those forms will kind of let us know what we need to do in our contracts in a way to inform it, to make it smooth, to reduce those fights. And one thing I've mentioned in my opening statements or opening comments, these other forms being attached to the contract in ways that they don't understand the legal benefit or legal consequences of it. And they're leading them down the road of breaching the fiduciary duties. And I've had two particular cases this past week where somebody attached the registration agreement to make it contingent upon it. And in those two cases in particular, they didn't tell their buyer that. And if they would have lost out on the offer because that was attached, not discussing with their buyer, then they're getting themselves in trouble and not helping the buyer themselves understand it. So if we look at these forms and if the concession route, my concern with the industry practice there is if we have what has by numbers wise been done where there's another agreement already out there, the broker under the new rules puts it on their website, right? If these new rules go through and that becomes a practice, they've made that offer. Somehow a buyer's agent or broker accepts that offer by bringing the buyer under the terms of what now would not be MLS terms, but terms of that broker offering it. But then they go to the contract stage and they receive an offer from a buyer that includes more concessions to pay for commissions. That seller then is going to be making concessions in the contract and they're going to be paying their broker who then pays whatever percentage that might be. And so that's my concern on going the concessions route, as opposed to making maybe the commission language more robust or compensation language if we want to go there. I know there's comments in here about commission versus professional compensation. There's actually a definition in the rules of commission, which includes any fee for brokerage services. And now that may not be, people read into that and don't see it. So they see commission and they're more concerned about antitrust things. But we do have a definition in our rules that says commission is not just commission. It's any fee related for brokerage services. And so I don't have an answer for any of this because I think we're in this limbo of not knowing what actually is going to change. And I think our committee in particular is in a very difficult position. Because if we make a change now and anything's changed in those settlement agreements or in the rules and then the actual, for our concern, the practice that we need to facilitate, maybe we went the wrong way. Maybe we didn't. But at the same time, we do have an issue right now that's out there and it's happening a lot. And so I hope today through our discussion, we can try to find some middle ground. We can try to find a way that may not be perfect. And being not perfect, maybe doing nothing until it's finalized. Maybe it's doing a little step. Don't know. But I think that's what our focus today is, doing the best we can and acknowledging up front, we're going to have to revisit this. This is going to change. It's so fluid. And it's been one of the biggest changes in our industry in a long time. So.
Just to address one of your concerns, not fully, but here's additional information, is that under the settlement agreement, a member of an MLS, before they can show a property, show a home to a potential buyer, they have to have a written agreement. So that's kind of what we're looking at. We have a 5-page buyer's rep agreement. We know buyers don't want to sign that anyway. So we're looking at that issue. That agreement, or any representation agreement, has to clearly state the amount that that agent's going to receive from any source, and is limited to that amount. It's capped. And so we're trying to figure out how to ensure our brokers can get paid, maybe from multiple sources, but there is going to be that push and pull with that money, commission or compensation, to that broker who's representing the buyer, because they're going to be limited to what's in their written representation agreement with the buyer, even if it's money from the listing broker.
Does the settlement agreement mandate a buyer rep agreement?
It mandates
before a certain time?
Yes, it mandates
At the first show.
a written agreement before showing a home.
Okay.
That's
And
what's-
don't ask me
You
to
didn't watch
define
CNN? I mean.
showing a home.
No, I
2020.
So it's weird.
all right. So they're going to have some form of buyer rep agreement before showing properties.
Yeah, and it's written that way because not all states have agency requirements. They can be transactional brokers, so it just says written agreement.
Okay.
But we know we're working under our Real Estate License Act.
And to clarify for the benefit of the public that may be watching this and everybody, the settlement agreement directly addresses the NAR rules. And one thing as a committee we also have is to protect the license holders that are not real members of NAR, which then are not realtors, and also the public that uses the form as well. But as far as the restrictions, the number of license holders that are members of NAR, I think greatly exceed the ones that are not.
Yeah.
And so that's where we look into the actual practice and tying in what changes are made in the rules to what we do, because by necessity impacts the practice. And I think that this is more for the benefit of the public. We all understand it there, but I think there's a lot of misunderstanding that these are hard and fast rules for every agent out there, for all the public. This is something that's going to be binding on everybody. Well, it is binding on the NAR and the members of I guess the settlement group there, but it doesn't necessarily impact the public directly in terms of the restrictions. But I do have a question on the legislative level. With DOJ's opinion in the other case, or intervention in the other case, they're pushing for a complete ban, it seems like to me, on cooperative compensation, meaning it's a listing agent compensating a listing broker, compensating a buyer's broker. Are there any legislative efforts that you're aware of that they're trying to push to actually make that go through, or how they might try to accomplish that outside these lawsuits?
There are none that I'm aware of.
So how are y'all addressing the question of the buyer going directly to the listing broker for the showing and offering?
We have just started that conversation with our task force last week.
Okay.
There was a whole discussion about sub-agency and whether it's truly dead or not, or whether we should go to the legislature and
Kill it.
kill it. I wasn't going to say that. We've just begun those conversations. I know we need to have them quickly. We're working under the settlement timeline, but also our legislative timeline, which is a whole year away.
So how does the settlement address that issue, or does it?
It does not.
Okay. It just says the buyer's got to be represented?
Yes. Well, buyer has to sign a written agreement.
Buyer has to sign a
before-
agreement.
Before a realtor can open the door.
It's the tour, the property language, it's the word tour.
So the written agreement could be, I don't represent you, but I'm going to show you the property.
But in Texas, we don't have no representation.
Under the settlement agreement,
Listing
yes.
agent goes directly to the listing agent.
They're representing themselves, okay.
Yes, but how, I'd be concerned how that agent shows that.
Lee had raised it. I'll get
No, I'm just saying, I'm just talking about the scenario of going directly to the listing agent.
Yes,
So if
it didn't speak to that, but we assume that that can be a pop.
my agreement is to show you the property, but not represent you because I represent the seller.
Yes, NAR has issued an opinion that open houses should not be affected by this. You can open the home in that way.
And so,
They didn't talk about calling on the signs.
Okay, thank you.
and we had S.J. Swanson join us on Zoom here, and both her and Lee have their hands up. Lee, I believe yours was up first, so if you want to jump in.
So on paragraph 8B, I don't think that needs to completely come out. I do think it needs some adjustment. And this goes back to, I mean, you really teed me up a while ago when you were talking about the compensation and coming from maybe two parties, right? So there will still be separate written, I mean, we're still going to have a listing agreement. We're still going to hopefully have a buyer agreement, right? So it could be that part of my fee is coming from that buyer and part of my fee is being paid by the listing broker to get to that total fee. I mean, there's still going to be separate written agreements with our consumers for compensation. So I'm not comfortable taking it completely out of the contract, but at the same time, I know that what we have isn't sufficient. So I think that's just something to consider. And they may have, when the Texas Realtors Forms Committee met, they may have had that conversation. If they've got some input to make me feel better about that, I would love to hear it.
And maybe the word needs to go from are to maybe.
Yeah, I was gonna say may.
Yeah, and it was just trying to anticipate all of those different methods of paying the broker. And so that was the reason for the suggestion. I think that if the committee feels changing the language and making that adjustment is more appropriate, that would address the issue as well.
Maybe.
And we'll jump to SJ, then we'll come to Melissa. SJ.
Good morning. I'm 100% against changing anything right now. And again, as others have at least touched on, with all respect to NAR, there's lots and lots of licensees who are not members. There are lots of properties that are never listed on an MLS. I would venture to say that the majority of the farm and ranch are never listed on a traditional MLS. And those folks do not have to abide by whatever it is that comes down if and when it does come down. You know, and a judge has got a rule on this and they haven't ruled on it. So anyway, it's unfortunate that there's a time crunch with some things that aren't actually final, and the legislature doesn't start until, January. So, but I just don't know how we can do anything. I think we would really be stepping way too far out. So that's my comment there. Thanks.
SJ, are you driving and meeting at the same time?
I am not. I want you to see that I'm parked, and I want another person who was possibly thinking about doing that last week during a BLC meeting to see that.
Well, and that goes in, I think, with the difficulty of the situation that we're in. And Melissa,
I was just gonna kind of mention what I was gonna go back to what Lee said. Oh,
You go ahead and I'll go next.
I'm just curious if we took it out, because I feel like there's some obligation somewhere for transparency, right? And so if we completely take it out, then we're not being transparent about where anybody's monies are coming and going from. And so I just feel like adding maybe may or shall or something like that. Not everybody's always doing it this way, but make it a little bit more fluid, but have some kind of, I feel like there has to be transparency. So it's just my thought.
Okay. And my two quick questions to Texas Realtors. The use of the word commission versus compensation. Am I correct that the word commission is not to be used, but compensation instead of? Or is there no statement on that?
I think we went with compensation because it covered, it's a little bit more broad. It includes the concessions, it includes different things that commission, is a defined. So I think that we were trying to just be more broad on that.
So it's Texas Realtors, not the lawsuit.
There's nothing in the settlement or that says you can't use.
Thank you. And my other question, number 4, where the disclosure section sits at the bottom of page 10 on broker information. If there was, they're taking the word.
I think you might. She's mute.
We lost sound, guys.
There we go.
There.
There we go.
If the compensation language similar to farm and ranch is updated across all contracts, then I think that this language would not be necessary.
Right.
Right.
I think that's the answer. Thank
Yeah.
you.
Thank you.
And Ron,
Yeah, I'm gonna go ahead and throw it out there, which is a perfect segue with, why don't we just take out, and I'll throw this out as a question more than a preference, but why don't we just take out everything dealing with brokerage fees out of the contract forms and throw that into an addendum? And then in the event that things change over the next year or two, we're just changing the addendum. We're not changing the form. And why not go ahead and just do them all the same for all the forms? So you have one addendum, throw them in there and you go. It would allow an immediate action if we need to here in the next few months. And then we can change it over the next, I'm sure this is going to take 10 years to probably final out before you know it. So.
I also think to the point of clarity that having an addendum that provides for the options, because there's not just going to be one or two, there's going to be multiples, and make the parties responsible for filling it out makes it easier to not have argument between the brokers, because historically we've said, well, MLS is going to control and we're not going to be there anymore. And they just have to itemize it going in. Makes it easier for everyone to understand, and the goal is consumer education.
Right.
I think the consumer would also see, oh, there's other options.
Yeah.
Yes.
Mm.
It will.
Depending on how we write it.
Well, sure.
Thank you for recognizing it so many times. I just wanted to clarify, I didn't say this initially, but one of the potential unintended consequences of all this is lack of transparency. I know that these lawsuits were brought by consumers. I know the DOJ is concerned with consumers, but we have a fear that taking the unilateral offer of compensation off the MLS, knowing not every license holder is a member, but a good percentage of them are, where is that information going to live? We don't know that yet. There's going to be different models that pop up. And so we, as a trade association, are also concerned that there will be a lack of transparency into agent commissions or compensation. And so I think I can say generally will support whatever you all think is the best approach for that transparency that you've been talking about. We're going to support that, because the last thing we want is additional lawsuits down the road. Anything that we can do now with the TREC forms for all license holders that ensure that there's transparency and clarity in how license holders get paid will be 100% supported, because that's going to be something that how this plays out, talking about, the multiple iterations we may see in changes, is going to be very confusing, mainly for the consumer, but also for the license holders. So I just wanted to say that.
are you aware of any study out there of the other states that I assume somebody in the process of these suits has gone through and said, here's how it's done in each one? And we've talked about a few on this committee in the past, but we've never done a complete survey just to get ideas from other states. And I don't know if one was readily accessible, maybe that we could have the benefit of.
That information doesn't live in one place, so there's not one comprehensive study, but we are happy to get information that we can. We've got a good network among the states, so we can get information. Nobody at this point, I think, has a perfect model out there. Everybody's having to change something. And so no, it doesn't really exist right now.
Even Washington, it requires buyer's rep.
There are states that have already legislatively required buyer's rep.
Yeah, and what
I
I'm
can
going to,
speak to that.
Well,
go ahead.
So, 2 years ago, Washington was ahead of us. They took any compensation out of MLS their state legislature required buyer broker agreements. And what they tell us right now is that the average fees for brokers have gone up. And they're seeing, I don't know that they've had any actual lawsuits, that have like made it to court because, things settle before they get there. But they have had some challenges with brokers offering different compensation to different brokerages or different agents. And they've had some code of ethics complaints related to fair housing. So there are some, I'm not saying that will happen everywhere. I'm saying those are some legitimate concerns, right? But that's what we've seen in Washington. Australia has a similar model as to what we might be looking at. What hasn't been in the news a lot, though, is that in Australia, on top of the fees that are paid, they also pay a flat fee just to get started. And it's not like a retainer. It's on top of the commission or percentage-based compensation. Does that help?
Yeah, and it does, and really, it's teeing up all the models so we can see what's there, right? And I always like knowing as much of the playing field as possible before we, get in to make a final decision. Because if there's another better way to do things that we're not aware of, it's definitely something we should take a look at, especially in these places that have done it for some years, and we can see the consequences of their actions. And again, I don't think it's our place to put a thumb on the scale. We do want to make things efficient. We want to reduce controversy, and however that turns out in the practice. And so, but necessarily what we do will impact it. And so
in alignment with reducing controversy and making sure that we make sure everyone's understanding, we're going to have to do a little bit of something now. I don't think we can wait and just do nothing right now. We've got to do something, because the same way you mentioned about the situations last week, we're already seeing a variety of offers come in that have weird things attached to them. They're very creative. That is not really showing the transparency that is why all of this occurred. And so I like the idea of exploring an addendum that's very simplistic with all the options on one page, very simplistic, where every party can see where all the different monies are coming from, because we are seeing buyers are paying a portion of the commission and then the seller's paying another portion of it. And we're seeing additional broker owner registration agreements on top of the listing agreement, on top of the buyer rep agreement, and all attached to forms. So I don't think we can just sit and do nothing, because our agents, the consumers, need us to do something and then continue to move along with the fluidity of what's happening.
Well stated.
And Tony?
Inherent in writing or authoring an addendum or any language is basically us steering with maybe guidance from Australia or UK or a lobby trade group sitting in our room without the plaintiff law firm in here. We're only hearing one side. You wanted to balance. We're inherently writing something that is steering the parties in a way that, what I'm understanding the theme is, to make sure NAR members, TAR members that are buyer reps get paid. I mean, I want the transparency, but I don't want us to start doing this just to fix something that really, if our goal is to write contracts for those who can't practice law, for the consumers, for farm and ranch, non-members, and then we're here to fix something because somebody else got sued. Like, I think we need a balance.
That's a good point to bring up, that, and I want to make it absolutely clear for everybody, we're not for one side or the other. We're here as a consumer protection agency to make things efficient and to reduce that controversy. And so when we're drafting this, I would say we're absolutely not going down the path of making sure buyers agents get paid.
Absolutely.
We are wanting transparency. We're wanting it to come to life on how everybody's getting paid.
Yeah.
And there's a huge concern on buyer representation and making sure buyers are represented in what everybody agrees is largely the biggest transaction of their life. And going at it alone is concerning, and that may be one impact, and that may work out. But our form should be able to address all the scenarios because that will be more common. And
Sure.
And even though some of the language may go to facilitating and making it more clear on the compensation, which by a byproduct will help buyers agents form their agreements, definitely isn't going to be our intent.
Yeah,
But
well,
it will
free market still, like whatever we author, they're still free to do what they want to do.
exactly.
And John, I agree with your words, consumer protection. It's the consumer being hurt the most in all of this, in my opinion. So it's answering a call from all parties. So I totally support the idea of an amendment to make it clear. Clarity is important, consumer protection is important, and I think that would be the clearest and give us the opportunity to respond to the call that's there right now. We can't wait.
And to tee it up, and Mary, and then I'm going to ask Vanessa a question.
Well, if we don't do something, I mean, in a way, I'm thinking, why don't we do what Farm and Ranch has and just put it in the middle of the contract? Then it doesn't matter if you're an AR member or you're not. It's how everybody's compensated. Because we've got to do something, because paragraph 12 is getting very creative. And people are using their numbers as much as they can so that they can get, paid. Because some of the consensus out there is if I have a buyer's agreement, that is buyer's closing costs. And so I can put it in paragraph 12.
We have a huge education.
And it's all education, but
Yeah.
that's also, there's a million agents, a million realtors out there to talk about.
That's what's so much, once again, we lose the transparency, which is, doesn't protect the consumer at all.
You have no idea what's in paragraph 12. You're right. It's just an amount.
Reading.
And we're seeing crazy things.
And then they'll see it on the closing document and go, what did I agree to? So I agree with either amendment, or I also we have a Farm and Ranch that has that paragraph in there.
Well, it sounds like what Ron's saying is take that out of Farm and Ranch, take all broker fees out of everything else, and just create a new clean document that can be an addendum. Is that what you're suggesting?
And I think we jump into the actual substance next. So one other thing I want to tee up before we do that, though, is the timing aspect, because the timing necessary will dictate maybe some of what we do, and both in terms of the normal process and maybe even the emergency process. If you can tee up, if we had to do something quickly, what could we do, and what's the normal process if we did something today? That would be.
The normal process would be to propose, receive comment in July, and adopt at the August meeting. You wouldn't have, you can keep the rule open longer than that, the proposal. If you wanted a later effective date. I have to think about the emergency component. Emergency is really supposed to be like there's a little legislative change, some sort of imminent situation. So, yes, peril, I think is the word. So that would be, I think that's a hard sell, to be very honest with you, in terms of getting it through. So, but you could always propose for July, see you'll be further along, right? You'll know more on the MLS, or on the NAR rules. You can always pull it back. You could always make adjustments if you wanted to adopt in August, or you can slow roll it. Whatever you all think is the best approach in doing that, but I don't think the emergency route works here.
So the practical side of that is the earliest anything we could push out would be August, which is going to be after the at least anticipated implementation of the new rules. And if we went past there, the next day would be November, correct? The November meeting. So even if we did something today under that, the changes will have taken place when it gets out there. And then it's just how far behind are we with the ultimate changes that come down? Again, not knowing what those changes will exactly be, and if it's possible that the settlement gets pushed off and that the rules get pushed off. But I feel, unless somebody wants to go on the foundational issues, ready to jump in, maybe to start on talking about solutions that we can look at. And Ron's idea, I think, with the separate forums, a good place to start if you wanted to kind of lead that discussion. But again, I don't want to shortchange anybody's. Let's throw everything on the.
Well, that's like the gentleman. I think you said it, but I just digest it. Do we have an idea when the DOJ is supposed to figure out cooperative, not cooperative? Okay. Yeah. Okay. I didn't know if we were waiting on some judicial ruling that's supposed to come out any day. No. Okay.
They've already been on record in the previous case that they want 0 cooperative compensation.
Really?
The NAR settlement doesn't go that far. It takes it off the MLS, but it doesn't prohibit it completely. But the DOJ has put in a statement of interest in the previous case that said they didn't like it. They wanted all to be in the contract negotiated between us.
Contract.
Okay. So no, it's the unilateral offer of compensation that the DOJ has the problem with, not on.
They don't want it on the MLS and they don't want it outside.
They have gone so far in the Massachusetts case to say, we don't think there should be any cooperative compensation. To have it go away, not just from MLS, not from anywhere, just not having the ability for a listing broker to pay a buyer's broker is in that statement of interest, at least.
Now, the court doesn't have to hold on to that. They can still approve the settlement kind of over the objection of the DOJ, but then you still have additional DOJ investigations kind of moving.
Which the settlement itself allows for further, the DOJ process to continue and potentially further restrictions from that, from my understanding as well. There's language in the settlement agreement that may allow it to go through and then that proceed as a separate. And then we'll come to Brian. Straight to your question. We'll get Brian's thoughts as well. Then we'll go forward with the substantive discussion.
Okay, now look, I'm getting quite concerned here. Agree 100%. This is not an emergency. I agree with everything Tony has said. And I'm just flummoxed here that we are even considering. I mean, did we get out of the business of we're not getting involved in promulgating listing agreements? This is essentially the same thing. I mean, again, with all due respect to the realtors, this is an NAR problem. You know, and unless, I mean, seriously, unless the commission, and Chair Kessler, if you can guide us, unless y'all are directing us to do something, it is inappropriate at this point. We do, this is not our circus or monkeys. We are not in the compensation business. We're not in the commission business, as far as I know, unless something has changed. And the NAR getting in trouble is not that.
Thank you, SJ. And I think what the view, at least of a lot of us on the other side, is it's still consumer protection, and to make sure it's disclosed, and we're already seeing the consumer being harmed by the creative agent, whether they're a realtor or just a license holder, doing things that are ultimately going to harm the client. All that needs to factor into what we do, all these different thoughts. And Brian, if you want to give your take on it.
Everything that SJ said is 100% spot on. But I will also say that it's important for us, I think, to have some modicum of flexibility in our forms. And I think with the situation we have where a buyer expense is not broadly enough defined to include agreements concerning compensation, it may be handcuffing the ability of people to make agreements. I think there's a value in us making the forms flexible enough so that people can do what it is that they want to do with the least amount of change. But at the same time, we all have to understand that I didn't bring my magic 8-ball with me today. I don't know what's going to happen. And one of the worst things we could do is make wholesale changes to our contract forms before we really even know what the landscape is going to be. So I could see us not in an emergency setting, but modifying paragraph 12 of the contract and let it be worked out that way. But don't do anything greater than that now until we know exactly what's going to happen. And it's probably going to be 6 months to a year before we have a good idea of really what's going to be happening.
I agree with Brian. I mean, like, maybe we need to try something, but I just don't know that it's an emergency now. Let's let it play out and see what's happening.
John,
Sick.
I think we're trying to provide a tool to back up our agents so they don't do the unauthorized practice of law by misusing forms or creating other forms, answer a call of clarity. Even though the majority of our Texas license holders are members of an association, those agents work with the non-members as well. And there's the issue of compensation there. It is affecting all practicing license holders and the consumer. So to sit back and do nothing is not doing our job.
The contracts provide repeatedly, hire a lawyer. I know you're gonna say that not everybody can afford it, but if we start looking at that across the country, we got issues. Go hire a lawyer, write your contract so you get paid.
So these are all valid points.
Well, okay to tell the client to go hire a lawyer. I got hired twice on the drive up here by Farmer Ranch people. Tell them to go hire somebody.
Well, we know practically people aren't hiring, consumers are not hiring lawyers. That's just a fact, and by and large in these transactions.
True. So why put it in the contract over and over?
Well, and this is where I think there's valid points on both sides. There absolutely is for both sides of doing nothing to doing a lot. And it's not, we again don't have the magic 8 ball to figure out what's going to happen. One thing that's for certain is there's mistakes. There is bad representation happening right now.
Correct.
Because of misinformation.
Correct.
That I don't think anybody in here can honestly say we're seeing some crazy stuff in these contracts.
That's true.
And so that leads me to think we need to do something, even if it stays the way it is, to clarify it because of how public this is, how much misinformation is out there. They're grabbing onto it and trying to do stuff with our current forms that's not appropriate. And so I agree. We've never promulgated listing agreements or buyer rep agreements. I think Texas Realtors forms on that personally are pretty darn good. They weren't utilized enough, but they're there. But I don't think we'll ever get in that business. But again, our forms, we want to reduce controversy. And right now there's a lot of controversy being inserted. And so today, I think if we circle back, we need to look at the different options so we explore it. We can't just put one off and not discuss the merits. At the same time, I also agree with everybody that the action we need right now needs to be limited. It needs to be tempered. We don't need to jump on this bandwagon of the sky is falling. The sky is not falling. The practice, in my own personal view, probably won't change that much in the big picture. We have a good practice. We have people protected. We, in Texas especially, I think have a very good legislative setup. We have a very good truck commission. We have a very good trade association and other help. I think we'll figure this out. And I think at the end of the day, it probably won't be that different. But again, our forms need to address the reality of boots on the ground. And that's just tough. We're going to be in that tough position. So maybe if we explore these different options, keep that reined in approach and say, let's make the limited ones we think we need to prevent the controversy we're currently seeing. And then they're not going through. We'll be back here again in July to be able to go through the language, see what people comment on. We may have more direction from the lawsuits and then go from there. But I do think we need to do at least something today, in my own personal view, to address what we're seeing right now, but without going too far.
So I'm
sorry.
sorry.
I think somebody had their hand up online. Chairman, sir, did you have your?
Just real quick. I agree. I mean, we need to start talking about it. I don't think the commission or myself are giving any directions, but it is a consumer issue. Because our statute makes it very clear about representation and fiduciary, and this is putting a lot of cloudy substance in it. So I don't think it's a realtor issue. I think it's a consumer issue. And so I agree, we're not going to have the magic 8 ball, but if we don't start discussing and coming up with something then I think we're not only leaving the consumers unrepresented, but you're leaving your agent in a really foggy situation as far as fiduciary and representation. So I think that's why this discussion needs to be had now.
Thank you. Amy?
And I appreciate that, Chairman Kessler. I agree with that as well. I think I was going to try to move us towards maybe something we could do just kind of on your time. Let's go ahead and talk about maybe what we could do today if we were going to do anything today. My personal opinion would be that if we need to tweak some of the things that Texas Realtors has asked us to do in the contract form to allow to at least get us where some of the stuff is not like putting up barriers for agreements and so forth. And I'm not going to speak to the specific ones. They sounded pretty good to me, but I do like the idea of maybe us working on an addendum. My thought would be maybe a group could be put together to do that for us to look at the next meeting. And I know that will make it take longer. You know, it might not be till November until that could be approved in that time frame. But I would be uncomfortable with rushing on something as major as that today. Number one, because we are in limbo and we don't know everything, and what happens over the next several months with the cases and the settlements and so forth could affect that. And so for those that are concerned about our consumers, which all of us obviously are, I don't think anybody is saying don't do anything. I haven't heard anybody say we're not going to do something. I think what's being said is we can't rush into something and fix it all today. We're not going to be able to fix it all today. But I do think that's my thought process, is maybe we could talk about some of the tweaks in the contract forms that are fairly easy to do, that can at least address some of the concern. And as far as well, that kind of like blew my train. And then as
tweaking it.
yes, we're tweaking it now, but I think as far as I just completely lost my train of thought.
I think that's a good approach to look at, because the reality of today, if we went into drafting a whole nother form, we wouldn't finish it today. And I would, as much as I am hesitant to suggest this, with the comments we get back, a lot of this stuff, this separate form addendum idea and others that some of us may not have been thinking of, could come out of this discussion, right? If anybody's watching this meeting, geeks out like us to do this, and they send feedback back, right? Is there a way we can get feedback before the next meeting and comments? Is that appropriate? But my thought is the subcommittee, that if we go that route and form it, could have the benefit of the comments of those that have listened today and see the agenda. So we're coming to the next meeting more prepared to have at least addressed some of the ideas that may flow in. So I like that approach, and today's discussion, so we can actually get something done, could go on those tweaks, and not just Texas Realtors suggested ones, the other ones in the comments, our own ones, to see what's the minimum necessary we need to do today, and then have a subcommittee to.
And so I did catch my train of thought, and I'll finish my train of thought that I lost. What I was going to ask is, as to the major examples of the crazy stuff that's going on, inappropriate attaching of the things y'all were talking about earlier, is there any way that either Texas Realtors or TREC could give, and maybe you already have, give some guidance to them in the interim? Like, don't do, I mean, I know you can't say, please don't do, but is there something while we're trying to work this out, I don't know, is there a way of educating to try to cut back on some of that? I don't know. That's just a thought for, your email blast or whatever. So that was my other train of thought.
And I guess while they're thinking to answer that question, in practice today, yesterday, last week, the practitioner is out there in the field dealing with what we anticipate is going to happen. And that's why these forms are being used and misused, because they pretty much know what's going to come down in July. And I'd say that's what we are all in the field getting ready for. So time is of the essence. Will changes be made? No one really knows, but we're already seeing our agents out there following the guidelines they anticipate, and they're making do. And I think we're heading in the right direction. And I think we will react, and whatever is reasonable will happen. So I think we're heading in the right direction.
Larry?
I think brokerages are already looking at this. Brokerages are already hiring their lawyers. Brokerages are already creating their own forms and getting ready for July. They're not gonna work, they're not looking at us. They're looking at maybe Texas, but I'm saying all over. I'm seeing brokerages saying, we've got to be prepared for July. We're not gonna rely on anybody else. So that's the other concern, is because now we're going to have all these different forms out there because no one's guiding them. And you're going to have brokerages from all different companies with their lawyers writing their forms so they can clarify and have transparency.
So it'd be like commercial and farm and ranch.
Right.
Which is,
But that's hiring a lawyer. And you're not, I mean, if we're going to that rule, we're going to that rule. Here's a outline, call your lawyer. I mean, or like they do in statutory states or whatever, call your lawyer. I mean, I don't know, but they're either looking at us or they're going to need to look at their lawyers to make sure they're protected and their agents. I mean, as a brokerage, I mean.
That issue, it's, a lot of that is the broker to broker agreements, which we would never do. And of course, on those aren't even governed by the 53711. Right, but the 53711 agreements, that in my mind, okay. That's just like Texas Realtors doing one, just like, it's their own lawyer doing it. Now, it concerns me when they're doing it on behalf, like an addendum to the contract or something further, that I have seen as well come out of this. But that's where it's getting the problem attaching it. But that's, again, the lawyers doing it. There's lawyers in the background, but it's introducing confusion into the contracts to the extent the lawyers are giving bad advice, which we have no control over. But that is I see a positive and a drawback in different ways of looking at that, because it absolutely is happening.
Because I mean, if brokerages don't want them to put it in paragraph 12, they will have a form that they will attach to this contract to make sure there's compensation. And I mean, I don't think that's going to stop unless we have something with track, or everybody just mandate using a form from Texas Realtors that people use. But I think they'll attach it. I mean, I like the idea of farm and ranch paragraph going right in the middle of the contract. Personally, I think that's an easy.
We already have brokerages that, for example, do their own seller's disclosure. We have other trade organizations like local boards that have their own seller's disclosure, and they still use those in conjunction with the contract. I think the big thing will be to explain what can be attached, what can't be attached, what becomes actually part of the contract versus a disclosure. I don't know, because people are already, we've been doing that for a long time, creating additional forms. Makes sense?
Yeah, despite the rule that says if there's a promulgated track form, don't use your own form.
Right.
Right. That's what I'm saying.
Yeah.
Unless a lawyer, a lawyer or trade association.
Well, could I just put something on the table? My feeling is a minimalist approach right now is the best way to go until we see what happens. Make the forms be in a way such that it can accommodate additional addendums or agreements, but at the same time, don't get into the weeds. So, and let me just throw this out to everybody. First off, in paragraph 8B, where we talk about what it says separate written agreements, instead of having that affirmative statement that it will be in a separate written agreement, have a statement that, except for agreements expressly stated herein, this contract does not make provision for payment of broker compensation. That's my first thing.
Mm-hmm.
Second of all, 12A2, we would add broker compensation as being a possible buyer expense. And then number 3, in the broker information disclosure, delete all the references to MLS offer of compensation or other agreement between brokers and just say, pursuant to a previous separate agreement, other broker will be paid a fee of blank by blank. That gives enough flexibility. The parties can use our forms to do what is necessary to be done, but we're not going to get into agreements between brokers as to how they're going to do it or what. They're always going to be free to do that. And we maintain the status quo in that respect. Let's just have this form, our contract forms, be flexible enough to accommodate all the things that are going to happen that we don't know what's going to happen.
But yet we put that wording in when we don't know what's going to happen, as opposed to the earlier suggestions of taking anything that's got to do with compensation out of the contract and into the addendum. That's going to be a lot easier to change than if something does change. And our farm and range contract, as it is, does not talk about listing broker pay. It's got the wording that this body created that is already living, that ought to go be, on under these circumstances. We don't have to recreate the wheel. And I think that's getting too much into the weeds myself. I'm much prefer seeing it all on an amendment.
I don't have a problem at all with us. And I think it's a great idea for us to eventually come up with some sort of explanatory addendum so the consumers can see, okay, this is what the commission is going to be, and this is who's paying for it.
Well, if I can suggest this to the group, to marry all the approaches today, I think it would be a benefit for time's sake if I don't think we're going to be able to draft another addendum today. I don't think we can enough time. So just firmly saying, we'll put that to a subcommittee. We'll form a subcommittee at the end of today and we'll do it. Well, I think today, though, we do need to look at contract changes and give all of our opinion, and we can say we have this much time to give our opinion on how we think it should look. And then that way the subcommittee can leave this meeting with the benefit of at least the collective knowledge from the group. And then they can take that back and analyze it and come with a proposal or multiple proposals to say, here's how it might be done. And that way, at least the concerns that we have today would have been thought through and addressed, instead of coming to the next meeting somewhat flat-footed of not knowing how any member might have felt about it. And opinions are going to change. So anything that we would say today, nobody's going to be held accountable, because who knows what's going to happen practically and legally in between. But that way we can at least start advancing the ball. And I fully agree with you. I think we need to have some language in here. And I think it needs to be expanded as where it's at right now. I had not considered the addendum approach. I think removing it may make it simple where we can tie it in together. And I'm torn, as I'm always talking myself, of doing nothing too and just simplifying it. But I personally am more on the side of the fence of putting something in, but I don't want to rush it. And I don't want us to be here at 5 o'clock, having talked through everything and not get to the other business when I think there's more efficient
First,
way.
do no harm.
SJ has. SJ.
SJ? Are you with us, SJ?
Sorry. And I'm sorry I'm rolling, but I want to say a couple of things. Again, Amy, excellent. Second all of that. And reminder to the people who just or maybe you're not lawyers and can't remember this, but anybody can make a contract that they are a party to. So a broker who wants to make a contract with their client can do that. That is not the unauthorized practice of law to come up with a contract that you are a party to. So they can do that, again, on the side, whatever, with no problem. And speaking of that, it is my understanding that, in good practice, and certainly with what this lawsuit reiterates, that agreement should have happened between the buyer and their broker long before the contract, actually the proposed contract, the offer is submitted to the other side. So that's not the place it should be documented. It should have been documented already. And I had something else, but it went on the same train that Amy's went on, so maybe it'll come back.
See, I like Scott's face right there. That was.
I can't get past Wilson in the background.
Every time.
Yeah. Brings a smile to my face. Somebody else have a hand up?
Lee.
Lee? Oh,
Yeah, I like what you and Amy were saying about a subgroup. I think that's a good idea. I like the addendum idea. I would like to serve on that subgroup if you are to put that together. And then the other thing I wanted to say is the very idea that this is only about how we get paid and if we get paid is offensive to me. Because this is about consumers and transparency and them getting the representation that they deserve and knowing how someone's going to be compensated. There is no one in the room that works for free with no guarantee of compensation, and we shouldn't be any different. So I am offended by those comments, and I would like for you to, if you were feeling that way, I would like you to just reconsider your thoughts.
But on my, oh, I'm sorry, go ahead, Emily.
I was going to say that I agree because my desire to do something now has nothing to do with our compensation, because I agree the agreements should always be made prior to, but we're seeing literal agents doing negotiations and not having the clarity around them. Us protecting the consumer by having a little bit more clarity now and then going to subcommittee to work on an addendum is us doing what we're created to do. We need something now to provide the clarity because there's not that clarity for the consumer in any way, shape, or form with what we're seeing live every single.
Brian?
I just have to make the announcement. I'm on a conference call.
One thing
I
also
need to make the announcement.
One thing we need to also take into consideration
I'm gonna talk to you this afternoon.
the unintended consequences that might come.
Okay.
That people will.
The guy's gonna be there later.
On our guests, so all of our guests who are attending, could you please make sure you're muted? Thank you.
Go ahead, Brian. Sorry.
One fear I have with the addendum is that people are going to start relying solely on the addendum as being the agreement for broker compensation. Where, you know, a listing agreement has a whole lot of other stuff. A buyer representation agreement has a whole lot of other stuff. And people are going to possibly be steered to using the addendum. We don't need to sign anything else up, you know. So when exactly is the commission earned, and when is it payable, and what are the default provisions? There are all sorts of things that are contained in those rep agreements that we don't want to be putting into an addendum.
Right.
So we need to be very careful in drafting any sort of addendum that it doesn't become the default that people start to use that in the long run may be disadvantage to the industry.
Well, and I see the directive to the subcommittee that we form is to look at all forms and take all feedback back. And maybe this is a good point to move forward on looking at today. And then afterwards, at the end, we can kind of have our closing. Here's my thoughts on the bigger picture. And we may be more informed after walking through it and do it that way. So that way we can keep things moving.
What do you want to do first?
And so, what's that?
One last comment I was going to make is, you know, the whole point is consumer transparency. And when they get into the buyer's rep agreement, it's still an unknown about what the compensation is going to be because they'll look at different properties with different offers on the table. Contract is their last ditch option to look at and say, that's how much, okay, then I'm going to go forward with it. It really makes it very clear for them to see.
The other thing is, you guys all read the lawsuit more than I did, but if I remember correctly, it says with the buyer's rep, we have to have on our first showing. And then whatever we put in the buyer's rep, we cannot change that number. We can go down, but we cannot change. So now I'm an agent and I'm at a new construction home and they're offering a different number than what I put in the buyer's rep. As an agent, I cannot accept that.
Well,
So
that's a
higher number.
It's a little different. So you by mutual assent can always change your agreement with your buyer. There's not we're locked into this. It has to be clear. It has to be stated to where it can be easily. Yeah, it can be easily calculated. And again, that's going towards realtors, not the license holders beneath, but you do have that ability to change it later. And really, when you go to the builder scenario, that's coming from the other side and what they're offering. And the whole thrust of the lawsuit is the buyer should know what they're getting. And the concern about limiting it to that is not inflating commissions to then have the seller pay over what a buyer reasonably would have paid for those services to begin with. It is where I see the core issues that flow out of there's 3-4 pages of that settlement agreement right here that go to the change of rules. And that's all we have to go on right now. But nothing says you can't change it later by an amendment in mutual consent.
That would be a hard discussion.
Yeah, and
Go and amend what you're gonna be compensated for while the buyer's sitting there. I mean, I just think that's a really hard discussion.
Well, but that's there's lots of reasons. We'll come back to that when we talk about our own positions. But maybe we jump right into the contract
If you want.
and
Did you want to appoint the working group?
I think maybe we'll get to the end and then give our points and then see who needs to or who would like to at that point. Is the first provision that we need to address 8? I guess let me ask it that way. Is there anything before 8 that you think we need to address? Paragraph 8.
Of the
Where we at? So we'll start with the 1 to 4. So start 1 to 4. We're on page 12 if you're in the materials to the actual contract. And what we're doing here is looking at the compensation related language. Let's see if there's anything that we can do now to take this minimal approach while we have the subject working. And I believe it's paragraph 8 is the first time that it touches on compensation.
So I think the question on the table from the various perspectives earlier were, do you go with the deleting the whole paragraph, or do we just tweak it some, to, obviously it doesn't need to say all. So anyway, that's where I kind of felt like we were after I think Robin had kind of spoken to that.
We've had 2 suggestions mainly there. One, we had the rewrite of the sentence that Brian proposed earlier, and then I believe it was Robin who suggested maybe changing R to maybe contained in there. But the thrust of both of those is to remove the exclusivity of the commission being contained in a separate agreement to make it to where it's a little bit broader. And I think that's a fairly benign change that we can make here.
May I give option 3? Just delete 8B. Why do you need it?
No.
Why do you need it?
No, I think that's what,
I think that was
Ron
the
may
first
have been.
option.
Yeah, I agree with that.
No, I think Rob's
Delete 8B. And
That's not option 3, that's option 1.
That's option 1. Yeah, sorry. That maybe was the second watered down one.
I think this came because from a previous TREC meeting, a commissioner wanted to make sure we had it somewhere in here that it was a separate agreement. If I remember sitting at that meeting, there was a conversation. So they put it in there just as a notice. I guess you could say that.
I'm for take it all the way out.
I'm good.
I think if we take it all the way out, that would definitely need to be the case if we're going to potentially do something like in Farm and Ranch, where any payment for any professional services is covered somewhere else. Then it can't say it's in a separate written agreement if it's actually becoming part of this written agreement. Does that make sense?
It does. And I think if we take it out, it would elicit the feedback from others to what we're looking at, maybe the solution as an addendum or some other language. We're not making this change, right? We can pull it back and stuff, but at least we'll get those comments coming in to see what people think about it. So I'm okay with taking it out in the proposal.
I mean, I'm trying to right now with what you said, this scope, if we're gonna do something now, what can we little bit do now?
Well, these are just suggestions for now.
Correct.
Right. Okay.
Okay. So with that, any other comments before we move on? Well,
I mean, I think the only challenge here is agents think their compensation is on page 10. I mean, I hate to say that.
Well, and for your benefit, I know this happened before you were on the committee, but shortly before, we at one point suggested taking out the disclosure out at the
Oh, I think it should go out.
because, but when we did that, when we would go teach classes and ask, everybody said, well, where's our commission agreement going to be? And that proved our point of why we took it out. So we went ahead and put it back in with more language to make it clear that it's informational only, and left it in, but try to educate in the contract, which we try not to do. But so that's the history behind that provision. But okay, so for this suggestion on here in the minutes, we'll suggest taking out 8B altogether. The next provision, I believe, is 12, or next paragraph. And so there's the suggestions here, and please add the ones that I don't summarize, are to add, right now how it's structured, the seller's able to offer concessions, what we're calling concessions to the buyer. This is amounts that the buyer can use for the purposes stated in the contract, and specifically applied to buyer's expenses. And the buyer's expenses is a defined term in paragraph 12A2. And that defined term right now does not include commissions or compensation of any type to license holders or any agent. So the proposal is to add compensation into that as being an allowable buyer expense. So it's clear that if a concession is put in the contract or given by the seller, that it can be used for that purpose. On top of that, there was a suggestion that I think is a good one as well, to make it clear that's allowed by the lender, right? Because we have the restriction here in certain types of loans and certain underwriting guidelines for all loans that they can't use the seller concessions to pay for that type of expense. And so I believe that that's where the discussion centered around, and if anybody has more, Melissa.
So it says the following expenses must be paid at or prior to closing. And then there's a list of seller expenses. And I don't see anything on there, or I don't recall anything being on there that says, and seller has to pay their agent.
No, on this.
Yes. I'm just saying, if we're going to say it about the buyer, we would want to say it about the seller, because I would think that both parties would be paying their own agent or be the responsible for paying for whatever type of assistance they may or may not have received.
Well, can I make a suggestion here for this purpose?
Yes.
Is I think we're all in a consensus that brokerage fees should be enunciated in paragraph 12A 1 and 2. And leave it up to the working group to
Figure out how.
figure out where
Yeah.
exactly how that works.
Yeah,
Well,
I don't feel like this is something that we should change at this very moment, is all I'm saying.
Now,
Because there's so much more that goes into
the next question I think is concessions there, but I do think there should be brokerage fees should be enunciated as expenses of the parties.
Or maybe it's 12C.
Well, hold on.
Which doesn't.
I can see putting it in for buyer expenses, because that becomes relevant in paragraph 12A to, right, seller will pay some buyer expenses.
Oh, 12A 1B. Mm-hmm.
But we don't have a similar provision of buyer paying seller expenses. So I don't know, I mean, seller agrees to pay their broker.
No, that's why I'm saying.
That need to be.
That's why I'm saying is that we need to say that under 12A 1 and 2, that each party is going to pay the broker fees that they agree to pay. However that is, okay, in whatever form that is, they need to pay those. The question is then, how do we then develop that payment structure to take place? I think that's a different paragraph. Here, we're just listing expenses is all we're doing. Now, we can talk about concessions if we want to do that, if we want to take that separate issue. But I think the question here is both parties got to pay the brokerage fees they've agreed to pay.
Yes, and I think that the approach, real quick on that, is I agree with Brian. The thought in my head was to add it to buyer's expenses. If you add it to the list of seller's expenses, it becomes more complicated, because then you have to say, well, sellers agreed to pay it up here, and how do you make that different from the broker fees that you put in down?
No, I'm just saying is that here, if you list under the list of expenses under 12A 1A, right, you just put brokerage fees sellers agreed to pay. He does that anyway. In every transaction, he's paying, where there's a broker involved, he's paying brokerage fees now.
That's true.
Yeah.
Yep.
Sure. That's fine.
Okay, and Melissa, then we'll come to Lee.
So here's my take on it, right, is that say my buyer, just going to take y'all in a little story. Say my buyer has saved up $5,000 for their down payment and $5,000 for their closing costs. And so the buyer already has $10,000 saved in their little pocket. And they're gearing up to go to closing, and they need to come up with, let's just say it's $2,000 to pay a real estate fee. That's maybe an entire fee or a portion of a fee. It doesn't really matter. They owe this money and they don't have any additional funds. They have $10,000. They can still say, hey, Mr. Seller, I'd like you to pay $2,000 of my fees. Now I'm a buyer and I don't have to pay my appraisal fee or my loan application fee or my origination charges and all the other things that might be covered in that $2,000 I've requested. So now I'm only spending $8,000 at closing on this, and I have $2,000 in my pocket to then do whatever I wish. I can pay my real estate professional. I can pay my mom back for whatever. I can do whatever I want with that money, and then I should utilize those funds in the way that maybe I'm obligated to do in separate agreement that I made with my real estate professional. Does that make sense? I know that we're not talking about specific compensation. I don't have a better solution for how to make my story make sense. I feel like there's already a way to utilize this paragraph is what I'm saying.
And what I'm hearing there is not placing a limitation on the buyer's use of those funds, basically making it broad to where, to the extent allowable by the lender and anybody else that has authority over to make it flexible, which goes into using it for buyer agent compensation.
And that's all up to the lender. If the lender.
Well, then I
allows
don't
that
need
type
lender
of
approval.
compensation to be paid or not.
Yeah, I don't need lender approval because it's not saying that that's what it's going towards. Right? I've got my money back and I can do whatever I want to or need to with it. I can go buy a car with it, not with $2,000, but I can go do whatever I want to with that money, which may or may not include paying a professional for the services that were rendered.
It's still going to be subject to
Protecting the consumer.
minimum.
I wouldn't say that's protecting the consumer.
And I was Lee was hand up and then we'll come to Diane.
Thanks. Yeah, so I think John is right on because 12A1B already says, and then to other buyer's expenses as allowed by the lender. So if in paragraph 2, where we define buyer expenses, we add broker compensation, we don't have to say is allowed by lender because it's already in there. I think we're making this more complicated than it has to be. And Melissa's right. I think that this paragraph does need to remain to be as flexible as we've used it in the past, because I would rather see agents using this paragraph appropriately than doing some of the addendas and special provisions that we're seeing right now.
So you're saying number 2 would say any, like in the litany of list, any brokerage fees.
Brokerage
Not
compensation.
exactly, but something to that effect.
Something
And
like
my
Brokerage
concern
compensation, but leave 12A1 alone because it's already covered. It already says is allowed by the lender.
my fear that I mentioned at the beginning here of doing it that way is if the seller and the listing agent don't have a firm grasp that the compensation in the listing agreement is X, whatever X is, they enter this contract with an amount in there that is to include buyer compensation, buyer agent compensation. But there already is an existing cooperation agreement between those brokers. And so you have the listing agent already paying X amount. They have a separate agreement outside the contract to pay the other broker Y amount. And then you have more in here in terms of the buyer then getting an amount to go towards that. And so I can see it being a confusing situation on, okay, where are the funds coming from? What pot is it coming from? Is it coming from the listing agent's pocket? Is it coming from the seller's pocket? And if it comes from the seller's pocket, then the seller's doubling up because they're paying their agent plus that additional amount in there. As we know, the listing agreements now don't require an offer of compensation to the other side, right? You can put in there, we're not going to offer anything unless rules aside, or maybe it's minimal. But let's say they put in 6 and they're expecting 3 of that to come out to go to the other side. it's not in there. And they put another amount here that they're agreeing to pay. There's 2 enforceable agreements that could be doubled up. And I know I'm not being clear in that concern, but I've seen that come in that way where the seller, I don't think knowingly is agreeing to pay an amount over than the percentage in the listing agreement. And so I think by putting this in here today, we don't have to go into that. It can be a working group thing, but I would like that to be an idea in the back of the head on how to prevent that from being an issue.
So you're saying using a broker to broker registration on top of this, and so people are double dipping?
Yeah. So if
trying to
and
clarify what you're.
Yeah, and it's confusing, but how it comes in, so you have a set amount the sellers agreed to pay in the listing agreement. In most listing agreements, you're paying X percentage.
And somewhere we have to communicate that since it's not going to be in the MLS.
Right, so they have, it's not an MLS. They may or may not have made an offer of compensation out there to the other side. And so depending on the nature of that agreement, if they're expecting their listing agent to cover the fees to a certain amount, whether it's percentage or dollar amount of the buyer's agent's fees, but then they obligate themselves in here to pay even more on top of that. I want to make sure the language that if we look at changing it doesn't allow that to happen or minimizes the chances of that happening.
If the broker to broker registration is not attached to the contract, we don't know that exists. Okay, that's hanging out there. We don't know that it exists. What I have seen in the last few weeks is under special provisions, buyer's agent be paid by seller's compensation. I mean, they have made a statement, not legal, they made a statement of their compensation. I just think we're going to see a lot more of that stuff if we don't figure out how it's identified. Because I agree with you. Paragraph 12, you can put 19,000 there, and I don't know where that $19,000 is going. So I agree with that, but I don't know if we don't attach the registration between brokers and or somehow clarify it, no one's going to know if we're double dipping. You are absolutely correct.
Your concern actually might become the norm, which might be a good thing, because you might have an agreement with the seller that says, or the seller's agreement that says, I'm going to pay you 2%. And then I'll decide at the time of contract what I'll pay the buyer's broker. So in that kind of scenario, it actually is a good result for the seller.
As long as it's clear.
Yeah, exactly. Right. So it depends on what happens in terms of the norm.
Well, that may be
But
what
we
the
see that
DOJ is
happening in
looking
commercial transactions, commercial listing agreements.
Right.
I think that will happen. I think it will be part of a negotiation of a contract. How we can, especially if we happen to go into multiple offers again.
That's
I
great.
think it will happen.
Alling SJ, I see your hand up there.
She muted.
It takes a second.
I think your point's well taken, though, to be concerned about not inadvertently paying more.
So I'm not sure, SJ, if you pop in, we'll come to you. I think, so for this suggestion, is everybody okay at just inserting for now? Let's come up with the language, but so we can move forward of just in the draft, right? This isn't going out. This is to get public comment back at our next meeting, in my view.
Okay.
If we add into the defined term in 12A2, buyer's expenses, brokerage compensation to some degree. I'm not trying to think of the words in my head.
That buyer has agreed.
That buyer has agreed to pay.
Yeah. So why would we not do that in 12A1A?
Not necessary.
That's
Well, I
seller-
mean, if
that's
it's
seller's expenses.
So you mean brokerage
yeah,
compensation?
to
Sellers
me,
agree to-
right, yeah. Why would not the seller agree to pay his broker?
Seller may choose to pay it.
Why don't you
Well-
just say
I don't
brokerage
see the harm.
compensation?
Yeah, I think it's the brokerage compensation, because even if the buyer has a
Yeah.
buyer rep and once has agreed to pay 3%, they may want to use that portion of the seller's concessions towards what they've already agreed to pay, giving them the flexibility.
And that's where it gets into that broader concern of who's on first. Does it first come out of the listing agent's compensation, or does it first come out of?
Well, right now, you're just trying to get in
concessions?
this for feedback, aren't you?
Exactly. So, but that's that circular
Right.
thing. But if we put that in for feedback, we can we can live with that.
And the amendment will clarify.
Just a comment for feedback. I finally figured it out. I had myself muted and muted. But, you know, in Melissa's comments about the buyer being able to do whatever they want with their own money, I'm very concerned about that issue. And I want to make sure that Brian or someone that's a title company person is in the working group as well. I'm hearing mortgage fraud go off all over the place. I guess that comes from my countrywide experience way back in the day. But every closing I've seen for the last 23 years, you're signing off and saying, I don't have any outside agreements. And it is, as I understand, still the IRS's position that a buyer or a seller, you know, they get to write off their expenses, and closing or a broker fee, I think, is a fee they get to write off. So I don't think you get to go around and hide anything from the transaction, you know, the closing transaction, if there is a lender involved. So just keep that in mind.
Good thought.
It's
It's
my
an
main.
excellent point
Yeah,
to
thank
the
you.
amendment, because that's then part of a transaction.
Hey, could I throw something else on that, SJ? One thing that title companies often see, it's not unusual, is there's a disagreement between brokers who are not a party to the contract, and there are threats, you better not close that deal without paying me my 3%.
All the time. At least once a month.
Yes, thank you for saying that. That reminded me, it might have been one car in the train is back on the track here. Not in residential, but in other, you know, brokers get, if they know how to do it, they can get a lien for their commission for commercial,
Right.
and
But
I think
not-
arguably, you know, unimproved property. So, you know, again, I appreciate all these comments. I do think there definitely ought to be a working group, but we need to have, this needs to kind of be, I mean, our strongest, senior most people, and definitely a, you know, with some depth of experience on this
Fortunately,
working
she's
group, you know, and maybe, I'm not trying to create work, but you know, if everybody thinks, you know, if we need 13 people to be involved in this, then maybe we need to set another meeting for us. But I'm happy for it to be a working group, but it needs to be robust. You know, if I was making it up, I'd say Ron has to be there with his knowledge, you know, and I'd say Brian has to be there. I think Lee has to be there. I'd like to be there. John should probably be there. I think Tony probably ought to be there. You know, I mean, seriously, this is, I think this is going to be the high water mark for changes if we do this. And again, I'm not convinced yet that this is our swim lane, but there's so many things out there, you know, so many moving parts, and I'm getting real close to where I'm going into this meeting. So I will pop back in. Please don't do anything without me. That's all.
Hurry up and get everything done real quick.
I will. Okay, guys.
We'll talk to you soon.
You know, I can play this back, so I'll bust you. You know, as soon as they put the tape up on the deal.
Your
Anyway,
office, huh?
right. All right. Okay. See you on a little bit. Thank you.
Thanks.
Okay, so I think we're at the point on this one where I'm going to throw in one last comment on the adding the language. If we add brokerage compensation in here, are we going to spook everybody by making them think this is what our final changes we're proposing look like, right? The reality of people getting this without listening to the meeting. And so I do have that concern, even though it's not necessarily a real big one that we should make decisions on. But if they see minimal changes in here, they may think that's actually our final thing rather than just trying to elicit feedback. So
I think the commission can make it clear in their meeting that they consider this to be an initial initial change to the contract to provide flexibility, but they request BLC to consider the adoption of further amendments.
That would help smooth it over for me, so we don't spook everybody to the extent it gets sent out.
That's on the chairman.
Okay.
Like
Well,
how we ask for comments and how we roll this out to license.
Okay.
So let me make sure, because when I first understood this, is this exercise of going around and looking at the forms right now was really as suggestions for the working group to consider in coming back with something? Or are you saying that you're wanting to actually publish something based on these comments right now?
So in the like red line revisions that we have in the form here, that's where what I'm talking about. Not to send up to the commission, not to do that, but to have it in some red line format. So when the public receives the
I got it.
meeting materials for next meeting, they have something in there to chew on. Even though we know it's not going to be the ultimate.
Okay, that makes sense. That makes sense. Okay.
I think this of any issue is really calling for so many different sides feedback. There's industry, there's the consumer on each side of the consumer. The more we can elicit feedback, I think the better.
Okay, I understand better.
So what did we decide?
So, yeah,
What is there?
So I think Ron's can you want to pull up and see where we insert the brokerage compensation?
Yeah. So actually, I was just writing it in the minutes, but get to my teams. Thanks, so I can share.
Then after this, maybe we take a short break. Get some water and use the restroom.
Could we put it in two places in there for under buyers and under sellers?
I think that's where we ended up.
All right.
So what I have here in the minutes is that you asked for comments related to broker compensation for consideration by the working group. And then I started writing down those suggestions, which are really just summarized in 1 and 2. And then in number 3, I say that we're going to include those comments under 1 and 2 in the current working drafts.
And I think we may be able to expand on that a little bit when we do the round robin room in terms of the ideas that are thrown out by each one. So maybe we can circle back to make that a little more fulsome.
What is D1 and D2? I'm not sure I understand.
That's what you're saying.
We go up here.
John,
So this is that.
Yes.
Oh, thank you. That
Oh.
makes more sense.
while he's working on that, could you clarify something for me? I did not fully hear or understand the discussion about 12A1. It already says and other expenses payable by seller, but I'm understanding that y'all are adding compensation to that. I mean, I don't know that I really care. I just don't understand the need.
It says by under this contract. So all that we were adding is that
Gotcha.
if
That makes sense. Thank you.
And so this real quick. Before we move on and take a short break, does anybody have anything else they would like reflected in the minutes there in regards to paragraph 8?
so for the working draft, you just delete
Or
it.
sorry, 8 and 12.
Yeah.
And so are we going to defer, and I think I would agree with this, but I'm just for clarification on I was just kind of following TR's recommendations or suggestions. So for 12, at this time, we'll just kind of go with the issue on adding the seller paying a blank towards to buyer's broker. That'll just be a part of the working group.
Yeah, I think
Not look at that. I agree with that. I just
kind
wanted
of
to be
opens the
clear.
door to
Yeah.
the bigger.
Exactly. That's
Right,
part of
I
that
agree.
discussion.
Just wanted to make sure we're all on the same page.
Okay, with no further comment, we'll take a break here. Maybe you come back at right on the hour. 2-minute break. Okay. Are we off mute? Okay, so we're back in the meeting at 11 o'clock here. We'll continue on with the discussion just for brief initial suggestions. I believe the next paragraph we need to address is on page 10, actually the informational box, unless somebody has an earlier provision that they think we need to address. To tee this up, at the end of the contracts that Trek promulgates, all except the farm and ranch, there's not a commission agreement that's enforceable or between the agents in here. And there's not a commission agreement between the buyer and seller paying for any commission. What we have is a disclosure, and it's an informational only disclosure. We went over briefly earlier that at one point we suggested taking this out because it was causing confusion on whether this was enforceable versus an outside agreement. And clearly the outside agreement was what was enforceable, not this. When we then decided to put it back in to add additional language saying it is strictly for informational purposes. And the suggestions we received today, which are in the comments as well, is that to at least take out the word compensate, or to take out commission and put in compensation. And I think one of the suggestions was professional compensation. We start off, and also to remove the MLS offer of compensation, since it looks like at least that portion of the settlement agreement, if it goes through, will be a rule that it's impossible to do it on MLS. So here, I think if we take out that such as an MLS offer compensation at a minimum, and then we already used the word compensation in there, but we switched to pay or share commission at the end. Now, again, our Trek rules define commission, and the commission is a fee of any type for brokerage services. So it is a defined term that I think generally we're okay with, except for the confusion that it causes. So if we switch that to compensation, it doesn't concern me because it's still just as broad. But I think that's the two suggestions there. I think it's a no-brainer, take out MLS, but the other language, I would tee that up for anybody that has a particular opinion.
You know, they came after us with torches and pitchforks when we talked about deleting it altogether. So maybe now's the time we delete it altogether.
Yeah.
I would be fine with that too, especially since this is a good education point that broader things will be changing.
I think that's a great idea. Deleting it all together as well.
Okay.
Ask the chairman.
Lee gave a big thumbs up on the Zoom. Right? I didn't report that.
What do you think about removing it? Are you ready for the pitchforks?
I don't have a pitchfork. I'm good.
All right. Well, and this, again, we at one point in the past, we thought that was the best idea regardless of this issue. And so now it's I think a good time to throw it back in there as well, or to take it back out.
Easy.
Okay. So the next one we have in terms of the commission language is the farm and ranch. In our materials, that's on page 53, or if you're directly in the farm and ranch agreement, it's on page 10. The farm and ranch has, just to briefly tee up again, two different forms of agreements that touch on broker compensation. The first one at the top of the page on page 10 is ratification of fee. This was intended to confirm and be signed by the listing and buyer's agents to confirm the amount that they agreed between themselves to pay, what the listing agent agreed to pay the buyer's agent. And the history behind this, it was put in because historically a lot of properties were not listed in MLS, and they wanted to have a way to document whatever fee the listing agent agreed to pay the buyer's agent. And so I believe, and Ron has the history here, when that part was at one point suggested to be taken out, the pitchforks came out and it was put back in. Separately at the bottom, there's language that follows a lot of commercial contracts that are out there, and a lot of different contracts where the buyer and seller are making their agreement in the contract on how much commission they're going to pay and who they're going to pay. In this case, it's flexible where the buyer or seller can pay one commission, both commissions, no commissions, it's broad to be pretty flexible for the actual commission agreement. We have a statement in there that it should not be used if there's already a separate agreement to pay commissions, which goes to my issue I raised earlier with unintended consequences of adding language in paragraph 12 of the 1 to 4. And so looking at this, I'll tee it up to the group, so I don't have an immediate firm suggestion on this. If somebody has a suggestion, we can look at. I believe Texas Realtors comments really didn't touch on the farm and ranch as much as inserting similar language in the others.
Well, I would recommend right off the bat, deleting the ratification of fee as a proposal right now. By the time this is adopted, we may know more about the settlement issue that may dictate that otherwise. But if we delete that, we can leave the rest of it alone in terms of the agreement there. And then the working group can come back with a recommendation whether to include that in all the forms or not, or something similar to that.
And this goes along the lines of if it's being taken off MLS completely and we're not adding anything to the other contracts, this already was contemplating it not being on MLS. That's why it was in there. So by removing it now, we're just aligning it to the same interest as everybody's going to have due to the lack of the MLS availability.
You're saying remove it from the farm and ranch?
No,
The top
remove the
section,
top.
the top piece, the ratification of fee.
Oh,
And whether you like the bottom or not, leave it there, and that's for the working group to see where that
Right.
goes
okay.
in the future.
And I anticipate us receiving comments that put it back in and also add it to the other contract. I'm assuming that comment's going to come in and can be addressed and looked at by the subcommittee.
May I ask a question? So in terms of proposal, are you hoping to move forward with some proposals today?
That is what's going to be the follow-up. We wanted to push forward these contracts, and whether we need to do that now or we can wait to the next meeting. In my view, I'll bring that up. I was going to suggest we wait because we'll have more clarity at the next meeting. I think to make core changes, and I'd rather push it through altogether.
Yeah, I totally agree. I was just making sure I understood though.
Right. And thank you, because last meeting I was really pushing for this one to be the one to go forward. But I think with the recent events, it's reasonable not to. And so if we remove ratification of fee and leave in the buyer-seller agreement at the bottom, is there any language in the agreement at the bottom that we need to suggest changing?
I don't think
today.
No. Maybe not even later, but definitely not today.
And it's broad. It doesn't reference commission. It references fees, and it has the broad, you can do it either way. It's very flexible provision for an agreement to be made.
I have a question. So it specifies the buyer or the seller will pay the listing principal or broker, right? And then it says the buyer or seller will pay the other broker, but it doesn't address anywhere if there is a co-op commission of any sort, right? Which of course may or may not still be in existence later. But if we did take away the one on the top talks about cooperative compensation. And so I'm just not sure that if you do take the top one away, that you still solve all of the ways that people are going to potentially compensate their parties. Because if I only say, well, the seller's paying their agent and the buyer's paying their agent, but I don't know. I just feel like that there may be some representation agreement that says a certain amount and a portion of that's already covered here, but then the other portion's not. And I don't know.
Well, that's why this wouldn't be a finished working.
Right. Right.
That's why it's a work in progress between now and the next meeting, the subcommittee, to try to address what you're saying.
Okay, that's fine, as long as.
But if we
That's being
can go
thought.
here in the farm and ranch, I mean, is it gonna be a question to put it in the contract?
Yes.
That's one of the core things, suggestions that.
They took it out of, they took the ratification fee out of precedent. They changed that, what, 3 years ago? Maybe
Well, the informational item is still in there, right?
We
Right,
suggested
so-
taking it, and it wasn't a ratification fee in there,
Yeah,
it never
it's an
was. It's
information.
always informational only. And what we did was just taking it out because people were using it as an enforceable agreement. We're trying to.
It used to say ratification.
Yeah, I do think it used to say
It used to say ratification fee.
Okay.
I'm too old for that. I don't know. I don't know how many years. I don't know how many years, but we used to have the word ratification.
And all we're trying to do is put these into the working drafts right now to maybe generate some comments.
Mm-hmm.
Yeah, and none of this is the final changes. This is really to elicit feedback and get the interest holders to something to comment on. It's structure to comment on it.
I'm just saying that paragraph might work in all the paragraphs, in all the contracts now of what our situation is.
So I think with that, we can jump into the next agenda item. We're back on track here. Are there any other public comments on non-agenda items? Public comments? None in the room? Don't see any hands raised online. We'll go forward to the next one. Report by the BLC working groups. I did have some discussions up front. The Farm and Ranch and the New Home Working Group, and also the Oxford Comma, are going to push to next meeting for their presentation. The backup addendum working group, there was in the materials, I believe it's on 80 something, a proposed form based upon the language that we suggested last meeting. And we're not taking action on it today, but I would ask that everybody look at that form and be prepared next meeting to go over any suggested comments. There is a comment in the materials that we'll touch back on this. We'll be able to get into the language a little bit, at least through that. But on there, I would ask that we look at that working group presentation, fall back at the next meeting as well. And we have the disclosure working group. I'm not sure, is there reports?
Yeah, we had a meeting that was really more of what I call an organizational meeting of the scope of what we wanted to do, and then we'll follow up with some stuff. Obviously, we talked about Chapter 49 in the Water Code, but that's going to probably be legislative that we can get into more detail at a later meeting in terms of kind of the suggestions. Obviously, we're not a legislative working group, so I think we can just sort of make some suggestions about how that might look a little bit, and then see where, if anyone wants to listen, they can listen. And then we talked about the title notices in paragraph 6, which was where we spent most of our time, and to try to restate those disclosures in proper ways, possibly looking at maybe moving them around or changing some of the wording a little bit. We'll get those drafts at a later time. And then SJ was going to focus a little bit more on the farm and ranch issues and see if there's some additional disclosure issues that she wanted to bring forward. That kind of goes hand in hand with the review of the environmental addendum as well. And then the last two things we talked about was kind of refreshing our minds on FERPTA, just to have fun with that one and see where it goes. And then looking at the check boxes on the forms, on the disclosure forms, which I don't know if that's within our scope, since that's kind of a staff box. I don't know if we were going to see if that was proper for us to kind of even look at, or if you want us to maybe make some suggestions, or you want to leave that in the staff's hands. I don't need an answer today, but maybe later. Okay.
Thank you. And the next agenda item goes into discussion of deferred comments and recommendations. To tie into the disclosures, Brian Sledge reached out to me. He presented at our last meeting, along with Charles Porter, on the water disclosure issues and language. And he reported back, he was asking for feedback, if there's any comments, and we got these meeting materials. He noticed there were none directly on that, but he would like to provide additional comments and work with that. So if it's okay, I'll direct him to you, Ron,
sure,
for that working group.
Great.
There, and also I asked him, well, I'll wait, there's a water disclosure or the mud district disclosure issues that we deferred last time, and he provided an update, and we had a conversation about that. But there's a couple comments. I'll discuss those when those comments are raised. The other kind of, I'm not sure if it's a deferred comment, but we did have in our materials about the T-47 being an unsworn declaration. We made a suggested change to the contracts. I was just talking with Brian on the break. That hasn't gone through yet. It's anticipated to go through. It's in the package. It will maybe be sometime this year, later this year. But I think that's all the deferred comments that I saw. Materials. Anybody else have any deferred ones to discuss? So we'll jump into the next one about the discussion and possible action regarding comments received on contract forms since the last meeting. And these start on page 72 of our materials. The first comment was from Lee Easter, and he actually has 3 distinct comments. The first one is in regards to changes of the size of the blanks for the property descriptions, and specifically the 1 to 4 and some of the others. And I think this is more of a formatting issue for staff to look at on this to see. Some contracts have a longer blank for addition and others, and he makes some suggestions on how we can better make those blanks to fit how long those descriptions are. But I believe that's a staff issue. Can look at that. Second, he had a suggestion to require a cash buyer to produce evidence that they actually have the cash. So this is his suggestion number 2. And his frustration there is, unlike some mechanisms for credit approval in our addendums, that where the buyer has to produce evidence of their creditworthiness, he wants an actual requirement to say if you're paying cash, the contract's going to require you to give me evidence you have that cash. I don't think we need to go that far. We already have practice in place. A good agent's going to ask for evidence of funds up front, but I don't think that needs to be in our actual contract.
Agreed.
Number 3, he suggests the revision to the commission paragraphs to add a checkboxes, and of course that's going to be part of the subgroup. He wants a checkbox to be added, even in the informational only part that says whether it's cash, a percentage, or other. And he thinks we left out the word of, I believe is in his comment, but if you read it in context, of wouldn't make sense and where he wants it to add. But that's all being looked at, so I think we defer that comment. On page, and it goes without saying, stop me at any point if you want to talk about anything more or go through these comments, but I'll march through them. On page 73 of our materials, Ken Smith makes a suggestion to remove the word nominal from the option period consideration in paragraph 5B. He thinks we're putting a finger on the scale in favor of buyers paying smaller option fees. The paragraph itself reads that for nominal consideration and the payment of a certain amount. And the reason we have nominal consideration in there is to ensure the option agreement is supported by consideration, to make sure that there's something there that is in the contract to make it enforceable. This is one of the most important rights of the buyer in the contract. And so the history of having that in there is to help with enforceability. I personally don't think it puts a finger on the scale at all, but obviously some take it that way. But I don't think there's a way we can take that out, or otherwise make it less of it. For a twig, the old ceremony there. But so I suggest no action on that due to the legal reasons we have it in there. Let's see, Kirsten Crawford had a comment on the effective date language in paragraph 5 in terms of when there's a backup offer. She would like clarification of what effective date we're discussing in 5A1 in terms of when that additional earnest money has to be paid. So the confusion is if this says so many days after the effective date, well, the backup addendum amends the effective date. And I could see cause confusion, as she states here. Our backup addendum that we revised and proposed addresses this issue. You no longer have to do it in the contract and monkey with it. It's expressly stated in there, multi-stage, pay this much option, this much earnest up front. When you go in the first place, pay this additional amount. So you no longer will be using that blank, and I think it takes care of it. Let's see, Tracy Hammonds thinks the 1 to 4's name puts agents at risk of fair housing violations. due to familiar status being a protected class in certain situations. I don't think it goes that far. I think this is, I don't see the concern.
That's a federal term.
Certainly for lending purposes.
And so I think I don't see the risk there or any need to change that. John Taylor, I will say though, thank you for sending comments in. Even though we may not talk about it long and discuss it much, we appreciate the comments and want the comments coming in because it helps inform the understanding of the public and license holders to the language of the contracts and really helps us. So please don't be discouraged if we move on quickly. John Taylor wants clarification on the survey language. He thinks the language is unclear in specifically the first subsection where the seller has to pay for the survey. They don't timely provide the T47 and a copy of the survey to title and the buyer. We did last meeting make some changes to this to try to clarify that, to not only to break it out to say they have to provide number one, the T47, number two, the survey, or vice versa. So I think we've addressed this concern and talked about it quite a bit in our last meeting. We can see how our changes, if they go in, are taken by the license holders and public. I don't think we need any further action right now. Page 74, Salvador Caballero. Thank you, and I apologize for butchering the name. I can't say normal English correctly on simple words, so apologize for that. He wants to eliminate the option period, and he says it's cumbersome to title companies and harmful for the most part to the public. In fact, he says it's been a complete failure to our consumers. I had the exact opposite take on the option period. It's one of the most important things we have in the contract. In the suggestion that he has to return to an inspection time period. And I'm not sure what he means by inspection time, because that generally would operate the same way to get the buyer an out. But he's concerned about tying up properties and having an option period all to tie them up. But I think this is more of an educational issue on how it operates. And the contracts I think are fairly drafted between buyer and seller here to provide for it.
I think where he was going with it is the option period is an unrestricted right to terminate.
Yeah.
And he's trying to make it, you can only terminate for inspections, not because you found another house the next day that you loved more.
That's a good.
I think that's where he's going. And he also mentioned that the amount of money was inconsequential and laughable. And I think that goes back to the other comment 3 people ago or whatever. And maybe that's just a matter of practice that if we don't like the number, we should start making a higher number go in that blank when we submit our offers.
And that's exactly right. And we've seen that in this market increase. I've seen more and more substantial option fees that are out there.
The other thing that came to me yesterday, it was someone that called me on the option period. They don't like the fact that they send in, an amendment, and I get this, and it's now 4:30 on the last day of option, and the seller's just not responding. And so they have to decide if they're terminating or if they're just gonna, go with the offer. And they do not like the fact that somewhere the buyer they're saying the buyer and the seller should be able to sign that they will give an answer by a certain time, because they're saying the sellers are playing a game. It's at 4:45. Oh, now we'll send you something, right? And they have 15 minutes to.
And that practice happens quite a bit. In with the way it's structured, it's in the buyer's hands. The buyer knows the deadline, should know the deadline, should be counseled on the deadline. And if the seller doesn't respond, be able to not wait until the last minute to begin with, but then if they don't respond, they know they need to terminate.
But they send it in 2 days early and the seller's just not responding. The seller's playing the game. And right now, and that's what they're.
Yeah.
And I'm like, well, you just terminate. They're going, well, we don't know if we want to terminate. Can't there be some kind of, and I'm just saying it came up, I got a call yesterday. Option period. It happens differently in other states. Let me put it that way.
Part of the negotiation.
Yeah, and I'm not sure how we can direct them to do that. That's a practice issue, and it'd be hard to address that in the contracts. I understand and fully appreciate the frustration there, and there's actually somebody else in here that comments on another practice that touches on it. which we can go to that comment. It's Ryan Kyle, I believe, at the bottom of that page.
Just don't forget to circle back. to
Yeah, I'll
Mickey.
come back to this one. Yeah, touches kind of, this one was a little, it frustrated that when they pay the earnest, they'll pay the earnest money in option money up front, then try to terminate. And that's a practice, especially a lot of wholesalers, right? Tying stuff up and not paying the fees. And in there, it's, I don't want them to be able to conduct an inspection until they pay the fees. And we've had that request come in periodically to this committee, is prevent the buyer from doing any inspections, not allowing the access under 7A to the property until they pay the earnest and option fee. And I think that's a valid discussion point, you know, on whether that should be.
Well, do they
Then
have,
we
do they
become-
have an option?
then
Do they
we-
pay the consideration?
Well, see, there's a deadline. So,
You have 3 days, so they're
You're
not.
talking about
yeah. So they, in this case, I believe she talked here, they never even pay the option and try to terminate. Then they're stuck in breach of contract. We know the practical side of enforcing these is difficult.
So.
But it's more important on, I think, the earnest money, because a lot of them pay the option, but not the earnest. And it's, they don't want, put up the money before you go see the property.
So like paragraph 7A, the first sentence, seller shall permit buyer and buyer's agent access to the property at reasonable time after the earnest money and option fee have been paid.
Yeah, but we
Look at
already have
Scott-
to
look at
give
Scott's
them.
face on that one.
I like that. You put it in the MLS, you need to be given access to reasonable times to any buyer. I'm just saying.
It's a slippery slope.
Oh.
Well, the result
You should
will
have
be
seen
to,
Scott's.
Yeah.
The buyer can be timely doing his inspections. Well, then why can't he be timely in paying his earnest money?
I agree.
And if, my view on this, it doesn't rise to the level that I think we need to make a contractual change. Especially with the note that the buyers are free, or sellers are free to add that language themselves or get their attorney to draft it.
And sellers have the right to terminate now, right? We added, sellers have the right to terminate. If you don't pay it, we don't have to sit around and wait for you either.
They can
It's a
negotiate.
3-day window.
Right. And they can negotiate higher numbers, yeah.
The question is, I have seen buyers who want to do their inspection the day after the effective date.
Mhm.
And they look at it, they kick the tires, they don't like it. And so they say, I'm out of here and I'm not even going to pay the earnest money.
Right. Right.
Yes.
And our contracts are structured with the seller, the earnest money is not timely paid. It opens up the window of time for the seller to terminate.
Mhm.
It's one of the powerful seller termination rights that is pretty easily documented by the receipt page. And so in that period goes until the buyer actually pays the earnest money. So the seller's not taken hostage here, right? And they can always move on, get out and move on. And in that scenario, well, I guess I was thinking about, do they have a cause of action for the earnest money, you know, to get out? But I think it's just determination, they move on, clean slate, and it happens fairly quick, 3 days, right? It's
Well, why not
the
just
timeline or
tie it instead of to the earnest money and option fee, just tie it to the option fee, because we already provide that a portion of the earnest money is going to go to the option fee first. That's going to be your only claim if they terminate within the option period. Is the option
Two
money.
separate
It's not-
fees, it's just that they're
I know,
paying
but
them
you
in
don't
one.
care
fee.
about that.
Right, right.
Lee?
Not every buyer who has an inspection also has an option period.
Right.
So if you say that the option fee has to be paid, you're prohibiting buyers without an option from getting an inspection at all. So, and I don't think that's what any of us want to do. I also think when you tie it to the earnest money, there are going to be circumstances where I execute a sales contract on a Friday. The buyer can get an inspection on Saturday, but they can't get earnest money delivered until Monday. As the seller's representative, I want them to get that inspection as soon as possible. If they're going to terminate due to that inspection, I want to know in a day or two, not 5 days, because we had to wait on them to put their earnest money in. So I would not be in favor of making a change to this. I do understand that sometimes there's challenges, and I think the way to handle that is through negotiations. I don't think it's changing the contract.
Agreed.
I fully agree with that. I think it's a good way to summarize it. We've looked at this a few times and I'm not taking a strong stance from anybody to make any changes there. And very well said, Lee. If we go back to Mickey Lackey's comment, wants option money to go to title. This is the additional option money to go to title instead of the seller. amendment right now states is past tense, in terms of the has been paid. So it says the buyer has paid the seller. And this has come up frequently on our committee. And we left it that way to ensure that it's paid. Normally it's nominal amount, right? We use that actual word again. And we wanted to protect the buyer's right to that extended period. But it is another fair discussion of it comes up consistently. It's almost every meeting somebody says we wanted to go to title and to streamline it. And I get it. The logistics of that may be a lot easier. We changed the option money going to title to begin with because in rural areas, and one of the reasons, tracking down listing agents, right, is difficult. Sometimes they don't have offices. Sometimes they don't answer their phone. How do you actually get it to them? Again, we circled around this issue and we never decided to make a change. So I lightly teed up to see if anybody feels any different now, but I think we've discussed this issue pretty thoroughly before.
We hit it hard last time.
Yeah, we did.
I think changing it to title doesn't, I mean, I think what I was hearing from the past, they were like, well, by that time, the seller will already have the option money and you can just give the additional earnest option money to the seller. The challenge is, and I don't know about Brian's company, but most title companies keep the option money unless the seller demands it. They just keep it and leave it as a credit, right? And so the seller never sees the money anyway. So with that being said, I think it would be okay, and I think it would be clear to the agent if the additional, and it will be paid, the additional money going to title, because I think a lot of times they'll put a number in there and it's never.
It doesn't pass.
It never happens.
Typically, though.
I mean, I hate to say that.
We're talking about the extension of
Right.
the option period.
Right.
Usually that is definitely a nominal amount.
Yeah, like $5, $10,
And
whatever,
so,
yeah.
you know, there's the Texas Supreme Court case that says, even if it's not paid, it's effective to extend the option because it is such a nominal amount for a short extension of the option period. And that's why that clause is written that way in the amendment. You don't really have to worry about it. And it really is going to complicate things to get it to the title company. I think you can look at it both ways, but in the grand scheme of things, in the overwhelming number of cases, having it go to the title company is actually going to be more problematic than just the amendment that acknowledges that it has been received. And execution of the amendment is itself a receipt.
I think that we're missing Mickey's point. I don't think she's asking us to change it. What she's asking for is some kind of a receipt on the last page of the contract, because when they do actually pay it, it's probably half the time they don't get their.
You froze.
Close.
Can you-
Amendments should be going to the title company. I totally get it. But they don't always. And so even if the amendment were, maybe we put on the amendment in that paragraph, this acts as a receipt, or we add a receipt block. But I mean, I get what she's asking for. And while I haven't needed it, I understand why many do. And we talk about this at every meeting. So I think we should be open-minded and maybe consider what's being asked.
Yeah.
So she's saying on page 10, put an extra block.
I don't like the idea of it going to the title company also for the reason that, well, what if it's only a 1-day extension and it's on a Saturday and the title company is not available until Monday for me to drop that off in their office anyway? Or if it's a $5 extension and it costs me $5 to send it electronically because there's a transfer fee. I think there's a lot of reason and rationale why we like the idea of leaving it to the seller. But I can totally see where we could put a block on the receipt page that just says, oh, and the seller signed right here saying that they got their $1, $5, $100, whatever they got. That the seller could say, here's the one page where I know the receipt of the contract happened, the receipt of the earnest money was arrived, the receipt of the additional earnest money. Could we put option money on that receipt page?
What if,
I mean,
Do we need to, because the language says buyers paid seller the additional money? And if title's missing it because they're not getting the amendment or they're not seeing the amendment, they're gonna miss out the receipt part too.
The amendment
It's not
itself.
Yeah.
Yeah,
Yeah.
So has received.
assuming that title
It
gets the
says
amendment.
I mean, I don't know. I pay for food and they still give me a receipt. I've already paid them at the grocery store or still get a receipt. Or they ask me, would you like a receipt? And I can decide if I want a receipt or not. I don't know.
There is a lot of confusion because I'm constantly providing feedback to other brokerages on, well, where do we pay this? So they're not understanding that it is a receipt in itself, and we explain that. So unless there's clarity, but that doesn't solve the situation about getting credit for it, because even if with a receipt on the receipted page and an additional block, if the agent doesn't turn that into title with the seller's signature, the same with the amendment, to show for them to get credit, if they want it credited back, then it's still going to get missed on the closing disclosure.
And you're going back to the agents or the seller having to receipt it again,
Mm-hmm.
which we've gotten away from.
Right. Okay.
okay, so I guess with that, we'll move forward, talk through that issue, and it is reaching slowly up that level to change, but I think now we'll stay with it.
John, whenever you're ready, there's food here.
Okay. We'll knock out a few more comments here, then we'll take a break. Kathy, is it Faulkner?
Mm-hmm.
She's with the peers of Forms in Contracts Advisory Group of Metro Tech Association of Realtors. She sent in several comments. The comment at the top of page 75 of our materials wants the references to commission change to professional compensation, which we've gone over. The next comment, Ann LaCosta, thank you. Wants a change in commission language similar to the commercial contract style. So committee can take back that comment to analyze it. Jeremy Reed, the next comment largely wants the same thing. Another one from the Metroplex Association, the Farm and Ranch wants the change in the seller's disclosure language in paragraph 7. Let me go back to my commentary, 7B, which we've gone over as well. Let's see, the next one, Garen Reese wants seller. Okay, this goes into a separate topic here of the seller's disclosures, and there's multiple comments on this. What is mentioned in these comments are the seller's disclosures that are contained in 4 of our contract. To set the stage for this, there are certain types of transactions under section 508 of the property code that do not require the seller to provide a seller's disclosure notice. Those transactions include essentially vacant property, vacant land with no improvements, and also can include some farm and ranch properties that where the value of the dwellings on the property are 5% or less. And it also excludes some new home properties. So those 4 contracts that we have, the vacant land, the farm and ranch, and the 2 new home contracts, have seller's disclosures built in. Those were in the contract for a very long time, and they were missed. If you were asked agents, about these disclosures, and by and large, not many did. And so we decided to make it more apparent by making checkboxes, to make it where it's not skipped over. And we had a very extensive discussion whether to make checkboxes, to make it a separate form, and really spent a lot of time on that. Now we've had some traction, we've had some practice with the form, and these comments that we have today have been repeated multiple times. It's confusion. It's confusing how buyers, when they don't know the answers, are to fill out the contract. And there's suggestions in here to either make it a separate form or to remove it altogether, are really what they're summarized as. I personally don't feel we're far enough along into this practice to have enough education out there, especially on how buyers are to fill out the contracts. I think the purpose was accomplished by now everybody knows they're in there. Right? We went over that hurdle and we expanded a little bit. And the reasons we're making these are to protect the consumer. These are big ticket items that, whether you need to provide a disclosure or not, need to be disclosed by the seller to prevent liability. And so the purpose has been met of people actually realizing they're in there, are figuring out how to fill it out, And to me, it's an education issue, at least still for now. And then maybe as practice goes down, we build up these comments, and maybe it's better to put it in an addendum. Or maybe, I don't think it, in my opinion, ever to take it out, but it's something we can look at, but I don't think we're there yet.
Education for sure.
Well, I
Or
think,
take that page and put it in documents in the MLS and you know your answers.
Well, I do. I know Ashley's not on here, but I do a lot of farm and ranch, and I am getting bombarded 100% about this, especially those that I'm on the broker lawyer committee raising all kinds of came with me like, we propose an offer on a ranch because the agent either doesn't answer the phone, listing agent, or we know we want it, drop it over there, but we don't know how to fill in those blanks. And one of them made a pretty good point. It's like, and then there's no deadline for when the seller has to check it. So we send a contract for $1 million and we're gonna do this, but we don't know what those say. There's no obligation contractually for them to even answer that. And they just leave them blank and we never know, like, hey, can you get that done? I think this is something that needs to be addressed by the Farm and Ranch subcommittee, kind of just kick it around and maybe come back and give you some ideas if we even want to do anything, like how to work on
a
it.
simple idea would be to make it just like the Wonderful Family, where you check the box. Buyer has received Trek disclosure form blank. We create a new form.
So when do you check it?
You either check it with the contract because the seller's given it to you, or you have the next box, buyer has not received the notice.
So buyers give the contracts. I send over a contract, you sign it, we drop it off at
Buyer
title.
checks that I did not receive the notice, and then, and I have 3-day right to terminate, or 7-day or
days.
whatever.
Oh, yeah. Right.
After I receive the notice.
Now, that's what the other.
That's what we do in 1-4 family.
That's the other person, to give a deadline, and if you don't ever check those boxes or tell me anything, I'm allowed to get out. But I think that's a working group.
I would agree with that. And we discussed a lot of this in depth at our prior meetings when we made the language change. So in the farm and ranch specifically, I think we're getting most of the comments. So that's a great suggestion too.
Okay.
So
And I
then,
think that was what Kathy's thing was about too, was the farm and ranch. To go back up one comment, I think we kind of, I felt like when you were going over it, that wasn't what I was hearing, but that's kind of what she was saying too, is in the farm and ranch, that seller's disclosure. It's the same comment basically as Garen.
Yeah, the feedback I'm getting is they love the disclosures. They're just having a hard time working.
Right.
Get the
Yeah,
same-
it's legit.
Right.
Yeah.
Right. And how do you fill it out if you're the buyer? You don't know. You can't
Right.
disclose it.
okay, so then, let's see, I believe the Monica's, Demore's comment and Moshe's too, there are largely on the same issues. So I think that's, with the food here, do we want to go and grab food? Then we'll come march through the end of these comments? Sure. So let's, maybe say 20 minutes to eat and then we can jump back into it. So we'll come back at 5 after. Thank you to Tony for providing lunch today. Very much appreciated. We left. Thank you. We left off on page. There's a 77. There's a supplement that touches on surveys that we'll circle back to at the end. But finishing up with starting 77 with Rachel Henson's comment on the non-realty items addendum. So it indicates at the top where it has the contract concerning the property at blank, that it doesn't have a unit number there. And brokers, if you can correct me if I'm wrong, I think this is really the software that they're using to fill out the form that doesn't automatically populate it.
It's a DocuSign issue. They need to convert that through the provider. There's nothing we can do with Texas Realtors for that matter.
So our blank in that paragraph is just a one long blank for the address of the property, and that's a software issue at different brokers. The next comment from Ken Smith is about the residential lease addendum. He wants a date on which the leases have to be terminated to be either blank or sometime much longer before closing. The concern here is our current draft says that if that particular box is checked, that the seller agrees to terminate all leases before the closing date. He thinks that's too late and wants to have it, I believe, at the end of the option period, or to have that to be some negotiated day in advance of closing. So when you get to the closing table, there's not any last minute issues. I personally think that the obligation's there. And if we move up any further, it raises a whole host of other issues. What if the contract's terminated by the buyer under another out? The seller already terminated the leases, or any host of things that could come out in advance. And if we went this other direction as he's suggesting, then we're just going to be faced with a lot of different things that come from it. Where if it's that big of a concern, I think it's a 5% bucket, they can write it into the contract. They can have their lawyer themselves put it in there.
Terminating leases is not as easy as they think, because you've got property code and the lease stays with the property. So anytime I ever saw this, I was like, there has to be other negotiation
Very good point.
behind it, you know.
The lease addendum actually specifies that this addendum doesn't actually terminate any leases. It says if you're a landlord, just because you want to sell your property doesn't mean that this is, it specifically says it doesn't terminate leases. You need to go back and look at your lease document.
Exactly.
So, yeah.
For the benefit of everybody, that's a good point to make that's listening in, because this document doesn't do anything to the underlying contract between the seller and their tenant.
Correct.
Period.
Correct.
And so before executing this, and this was an educational item, I think that was pushed out before, you need to make sure you have that right. Before you agree with a buyer that you're going to terminate, you first need to make sure you can. And then if you can't, and with your own legal counsel determine that you can, make sure you don't check that box. Don't obligate yourself to do something you're prohibited from doing under a lease. So I don't really take any action on that issue. The next one. So next one's on the fixture lease addendum. And addendum, and I thought, let me tee this one up. I think this is a concern that we may not have directly addressed before, and it is a pretty big concern in my mind. Whether we need to address it or not sure. But the concern here is if a buyer agrees to assume a fixture lease, and in this particular comment from Penny Moore, she's discussing solar panels. If they agree to assume it in the contract and ultimately are denied by the solar panel owner or who they're leasing it from, what are the result? Can the buyer then get out of the contract, or is it just a breach of contract and the seller can sue that buyer for not assuming it? Or does it create a situation that makes closing impossible or impractical? The analogy here is to or a possible solution, if it's a big enough of a problem or an issue, is the seller financing docs, or the loan assumption addendum, actually, that says you're going to provide X, Y, Z, but it has the clause that says the lender must consent. And if the lender doesn't consent, either buyer or seller may terminate the contract. I believe that's in.
Which addendum did you say?
The loan assumption addendum has that. They're talking about the fixture lease addendum comment. And so to circle back to simplify, what happens if the buyer agrees to assume a solar lease, but the solar company refuses to accept that assignment? It refuses to lease to the new buyer, to have them assume the lease. In our loan assumption addendum, there is an out for buyer seller if that happens in the loan assumption context.
Are we talking about solar panels, a purchase, a commercial purchase, and not a loan assumption of a residential loan?
I think all he's trying to say is to use it as an example.
Over here.
Exactly.
It's an additional debt, and then the lender might say, we can't make a loan because you have this additional debt.
Well, no, it's a lease. Actually, this is specifically a solar panel lease.
Yeah.
So if they say you can't assume the lease, then the buyer moves in and the lease is still with the seller.
Well, I think that where she's going is most of the time our assumption, right, which assumptions are never good, but our assumption is that if the buyer can't qualify to also lease the solar panels, they probably also don't qualify for the mortgage because the mortgage payment plus the lease payment is going to be too much money and they can get out under third-party financing.
And that's how I took this to be.
Right. But I think now that we're talking it through, because that's kind of my initial thought, but I think now that we're talking it through, I can still get the loan. The loan's not the problem. The mortgage itself is not an issue, but for some reason the solar panel company, who is not a party to the contract, doesn't want to allow for that,
But
right?
we don't have, our fixture addendum doesn't address that specific concept.
Yeah.
Well, why wouldn't this just fall under the default paragraph? It says the buyer shall assume. If he's prohibited from assuming, then he's in default.
Right, and instead of making them in default and having it come up of closing at the last minute, of having, I guess they're asking us to make some change so it doesn't reach that far. And the only other place I see we address something similar against the loan assumption that gives either side an out, not make them in default, but giving them an out if they unexpectedly can't get approved for the fixed release assumption. And I'm not sure this is a big enough issue. This may be the 5%, first time we've heard of it.
There's a lot of, now we're Austin, in this area, a lot of the new houses are coming with solar panels and leases. I mean, automatic, like all the home builders are just putting solar panels out there and they're coming with leases. So I just had one and they would not close until the lease was assumed, until all the paperwork was signed that it could be assumed. The title company would not close.
So the difference in Ron, in I think your scenario, if they're just in breach, that goes to entitlement to get the earnest money back. If there's an out, then the buyer can get their earnest money back. If they didn't do their due diligence up front to see that they can get assumed, then.
Right. That's what I'm saying is that I know it may be harsh in any one particular case, but to me, is if they can't assume, they default. So
there is, yeah, the director.
Somebody's got to be direction.
Maybe there should be.
So you better get your approval during your option period.
Would be a good idea, right? Or be prepared to pay it off.
And so what I'm gathering from this, I think this falls within that 5% bucket. And it's something we've monitored to see if it raises itself again to make the change. And instead of making it in the default scenario, maybe we look at making it a termination right for both sides with some time frame attached. But I don't think there's enough there to take any firm action right now. Any other comments on that before we move on?
I like the idea of just addressing it during the option period. And you just need a long enough option period. You know, if you're the consumer.
See, and she's in El Paso, so it is not just this also.
Yeah.
I think a lot of the new home builders.
I don't see that this is any different from qualifying for a loan. Once you're past a certain time period, buyer takes the risk.
Right, except for the fact our loan assumption has that out. That doesn't make it a termination right. It makes it, or a default. If the lender ever fails to consent with, there's even no time restriction, I believe, on that, then it's either side can back out the contract.
And remember too, these leases, it's not a binary choice. You can either assign or not assign. It's, you can assign, or you can pay off
Higher payment.
the thing. I mean, there's all different remedies that these solar leases have, and they're all drafted in favor of the leasing company, the solar company.
Sure.
So, I mean, you can assume a lease. The seller or the solar company won't release the seller from their obligation. That's sort of the implicit, is that the buyer's assumption will result in the seller being released of their obligations. I think it's a good question that she raises. I just don't know the answer to it, other than to be sure you got it all wrapped up.
And it goes down that slope of, once we start making things like that, whether we then start requiring credit documentation up front and put in all that extra language, it opens up.
Well, I'm assuming that the document prohibits, because she says he cannot assume. I'm assuming the document prohibits the assumption. So if the document prohibits the assumption's invalid.
Right. Yeah, like what if their document just said, this is not an assumable lease period ever? Could have. Yeah.
Well, that so it bleeds into our next comment for a different form. This again is from the Metro Tex Association of Realtors, Forms and Contract Committee there. Wants an assignment of contract form to be developed by TREC similar to the Texas Realtors 1943 form. I personally have a lot of concerns about that because the there's a lot of stuff in that particular form from Texas Realtors, I think, that aren't addressed, that leave buyers and stuff open to liability and concerns about, you know, when's the assignment done, when's the payment made, is there a payment? There's all these host of things that, one, we haven't received many requests for this that I recall, and especially recently. But it goes to an area that I don't think we need to get into because of how diverse of a form that would need to be developed for any particular situation. And it doesn't, you know, does the original buyer or seller get released? Does the original buyer get released? About the time periods in the contract, did they go out? All these different things that, if I was drafting an assignment, and my form assignments are pretty long, that address a lot more things than what's in the current form they're suggesting that we follow in Texas Realtors. Any thoughts on assignments? Have you had a lot of requests for them?
Really, anytime that we have a situation like this, the investor and people doing these types of transactions have their own forms developed by legal counsel, and that's what they're going to say.
May I say there may be some value in having a form because those guys don't know how to do it. No, they get often, they confuse a flip deal with an assignment, and
Well, why don't they just request the attorney closing the transaction?
Yeah.
Seems like, right? As long as the attorney disclosure is made, the title companies provide it, won't they?
they don't need no attorney. Attorneys got money.
No. They don't even pay the title lawyer.
They saw it on the internet.
And a lot of title lawyers, everybody's company at this table are just as bad.
Well, I understand. But this is a residential transaction on a single family deal. It doesn't have to be that complicated.
It doesn't have to be, but it still, yeah. And so do you think there's, we'll go down that side. Are you tempted to go down those roads?
Not really, but, I mean, even the TAR form is fairly simple for the commercial deal, right? Unless you're going to add a bunch of special provisions in, which we don't want to do. So, in my limited experience with assignments at closing, the title lawyers are usually doing it.
In the context that I see that makes me real paranoid about is the wholesalers, those that aren't doing it right, and then the basic term not as
we have a little
understanding like we have.
I need you to take the lead.
Ambiguity blows up.
Live with property management, but you take the lead on it.
Scott,
Sorry about that.
Okay, so we'll keep that in maybe back of our heads and see if that develops. And
So they're just asking for us to create a promulgated form?
correct. And then they attach the form from Texas Realtors and that they're suggesting that we follow. So we'll monitor that particular issue. So the next one is about the confusion. There's a couple of comments in here. The confusion on finding the information from statutory tax districts. When we promulgated the recent form was to follow the statutory language that was required. It's been in there for 40 years, just slightly changed. And it's, I think, rightfully causing confusion. This is confusing to everybody. I had conversations with what I understand to be one of the two law firms in Texas that represent all the districts. And they confirmed our suspicion. There is not a single place to go to get the information.
True.
TCEQ doesn't have it. No single entity that anybody's aware of has all the information that might be needed by the public and license holders. And with that discussion, and this was going with the water disclosure issues as well, Brian Sledge is looking into what kind of legislative thing can we look at. And we can't do anything legislative on our committee, but he is looking to go down the path of, is there a way we can enforce a particular entity, TCEQ or somebody else, to be the warehouse of all this information, to be a one-stop shop to go get? Or really, in my mind, we don't even know the playing field yet. We don't have a good grasp on the scope of every single one. And again, going through many discussions with them, they acknowledge the issue. And I think we have an industry player on the legislative front to help now push what we're seeing in the field with brokers and agents, buyers and sellers. So these comments that are in here are just note the confusion and want us to try to find an answer. And some of the answers that were discussed are that central database, penalties for districts that don't put up the required information, because it's required right now to be up on their website. A lot of them just don't do it. And so maybe a penalty for those that don't put it on there, some enforcement mechanism, which I think goes to the thrust of the comments that we have here, is asking for the same things, that we're handcuffed. We can't do anything more as this committee. It's more legislative. And I really think there's a big incentive for whether it's legislatively, whether it's a trade association, whether it's a private party, whoever comes up with the magic sauce to make this easy is going to have a lot of traffic. And so I think there's a lot of incentive out there if we spotlight the issue for somebody to get on board. So with that, quickly going around, if anybody has anything to comment, and there's nothing we can do on these, but if you wanted to throw anything for Brian Sledge's benefit or
Well, I think the easy solution is in districts themselves. If you can figure out which districts have to give the notice in the first place, because a lot of districts I don't think know that they have to give the notice. That's the other problem. So you got to satisfy the trigger as to what triggers the requirement to give the notice, because some of these water districts or other districts they don't have a clue. So once that's simplified, then I think what you do is that you then simplify the process of getting it out there. I think it's easy if you give it to the appraisal districts and then they just have a link, because they should be a taxing district there on every property. You simply click it, they then pop it up. But that's me. But I think the first key is simplifying the trigger. Brian and I have talked about it, and it took me an hour and a half to walk through the statute just as if I were a water district, whether or not I had to give it. I couldn't figure it out. And that was only 4 lines.
We get numerous.
Yeah.
Requests, all sorts of mysteries.
Right.
Yeah, it's a source of frustration in the field to not know who's on first with regards to water. And I don't know what the legislature can do, because they need to look at the whole thing, not just, well, here's the part that talks about MUDs. Here's the part that talks about PIDs. Here's the part that talks about WCID, right? Like, at some level, our state elected officials need to look at the whole thing as a group in a holistic manner and say, okay, here's what we got to do, because it does all need to be in one place. And some of it is TCEQ, and that's great. But in practice, the PIDs are most problematic because it's not everywhere. It's very fragmented. And so you do have a couple of main players that I think we can start with, but there's a couple of real estate agents that I know that they're like, I have a spreadsheet and I'll share it with anybody who wants it. And they're just tracking it as they go. But I mean, I don't want that responsibility on me. I don't want to be in charge of the spreadsheet. Right. And what if my stuff becomes wrong and
And they rely on title companies, and not all the title companies have the information.
Yeah, and it is simply not available in certain contexts, period.
Right.
And it is such a big issue for consumers in the state of Texas legislature, if you're listening, because of the termination right. If this information is not provided up front before, at the time of executing the contract, the buyer has an unlimited out in the terms of water districts, all the way through closing. And with PID, 7 days after the notice is actually provided. It's a huge right that buyer has that operates effectively just like an option period all the way through closing. And so there is a big need to fix this. And unfortunately, we're handcuffed as this committee, but we can raise the issue. If you talk to your legislatures about this or your representatives, let's make it known. And I think we're all begging for a solution that has to come from the state level, legislature level, to whether it's penalties, whether it's housing, like the trek with the HOA information, having a directive for TCQ to do that. something along those lines to make this easy, because it's not working right now, period.
Correct.
And the chair's got his hand up.
I agree. It's extremely difficult to find, but just like they want us to register the homeowners association, there's no hammer if they don't. About the only way we can find it is we print a tax certificate on everything we do, because that's really the only place where they're going to be listed is on the tax certificate here locally, because there is not a database, and I don't know if the locals will ever put one together. I just don't see it.
Yeah, it's a difficult position we're in, and if this powerful of a right is tied to providing at this notice, the state really needs to give us a better vehicle, better logistics to find
Agreed.
it, because it's harming the consumer at the end of the day. So then if we go forward from there, there's several, they describe their difficulties that Shauna Akisto, I believe, describes the difficulty in pretty good detail there. Thank you for sending that in. And the same thing for Tramuna Bill, is confusion with the tax and district disclosures, and she goes on her particular exposure or experience with it. So then we move to page number 86 of the materials. This is a comment from DFW City Homes, and it's in regards to the commissions. They would like to see the commercial contract style commission language to be added to all promulgated forms, which subcommittee will be addressing. And he attaches some of the information that NAR sent out in their public releases. And that's the end of the comments that were in our packet. We have one that was sent supplemental here. It's agenda item number 5, supplement, from Lori Tillman. And she has a few different suggestions. The first one is in regards to the survey language. And she's concerned, states that because of the copyright infringement concerns that are out there, why do we even have an option for the seller to provide their existing survey? And this gets into, I think, a legal and practical side. And we talked about this many times, looking at the survey language, that we're not aware, at least personally, the last time we talked about it, of any lawsuit where a surveyor is actually sued under the copyright infringement against somebody else. We're open to seeing those cases, but we haven't seen it. The issue that's raised is, if a surveyor has copyright language saying a survey can only be used for that particular transaction by those particular parties, can it then be used in a later transaction by that seller under the contract by providing it? And at that point, it's up to the title company to say yes or no. And title companies, at least now, by and large, are accepting it, even though it has that copyright language in there. They're saying we'll still accept it because of the practical side. Legally, it may be one thing. Practically, it hasn't been done. And I think the industry itself will shift. If it does become an issue, then we may need to address. I don't think we need to address it right now, because it hasn't been a big problem. Melissa.
So in my contracts class, where we talk about this kind of thing, I had a student one time who said, my family owns a surveying company, and she said the reason that we copyright our surveys is not because we don't want sellers to reuse them and buyers and sellers to have access. What we don't want is to have another surveying company take our information and create a new survey, call it their own, and charge a fee for that, so that the copyright intention from the beginning, now whether that's going to remain the case forever or not, and again, this was one person in one class, but she said the intention was, I don't want another surveyor to have access, and so it's copyrighted in that manner, but because that was their intent, not real estate practitioners, not buyers and sellers.
Their particular pain point that they're solving with that, or trying to solve, is against other surveyors, not the
Correct.
transaction.
Correct.
We're seeing it by realtors. I have an office
Mhm.
where their compliance person is telling them you should not allow your seller to provide their survey. And so it's causing friction.
Mhm.
I'm just curious what brought that up? Because I couldn't get a good answer. I mean, we've been dealing with the survey copyright stuff since they started allowing us to use them. I was just, if you hadn't heard anything, yeah,
No, she just gave the rationale as to
that makes sense.
their background of why we started copywriting them in the first place. And this is just an unintended consequence that we, as the public and as practitioners, are finding that it becomes problematic because then we don't know what that really means. What was like, oh my gosh, well, here's what it really means. It means I shouldn't use it, but that wasn't their intended consequence.
Yeah.
Right.
Remember that this question has been going, in my experience, has been going on for at least the last 30 years. Not that I've been around though. I know it's been going on for decades.
Yes,
And it is an acceptable practice under the title insurance regulations. We have the T47 affidavit. And I don't think that this is anything that this group needs to address.
Agreed.
Agreed.
So the next comment, we need something that provides evidence that seller received the offer. Too often agents wonder if their offer was ever even presented. This could be a separate form or incorporated into the contract. I don't think we want to go down this path I think a lot of the counseling on the new response time that was shortened, right? That necessarily will by obligation require them to at least acknowledge that a correspondence was sent that contains the offer. And so there's already some rules in place that you can't go past 48 hours without at least acknowledging you received it or something back in response to when you sent it. So I think that mitigates some of the concern. But even without that, I wouldn't suggest we would ever venture to say you have to acknowledge receipt.
Can I also mention that not that we are these people, but the trade association and their code of ethics addresses this, just saying.
Yeah, there is a form, right?
It's part of the code of ethics. Again, not all of our people, it doesn't pertain to everyone, nor does it pertain to the public, but it's covered for a large number of practitioners.
Okay, so going to the next one, anything we can do to remove the requirement of the addendum regarding rental flood disclosure from the seller temporary lease? And the short and quick answer is no, because the legislature says we have to provide it. We understand there's difficulty in the practice or silliness in the practice of why does the seller or buyer have to disclose to the seller they just got the property from whether there's any flooding on the property. Who knows best? The seller already does. So it is what I consider a silly requirement, but we can't do anything about it at this point. So that takes us to the end of the comments section. We move to the next agenda item, discussion and possible action regarding recent court cases. There's one case attached to our materials here on page 94. And I just love these type of cases. This is an interpretation.
True lawyer.
I am a nerd. I geek out on this stuff. I love when it comes out. And this one, it was regarding an interpretation of the mechanics lien statute. And specifically whether the use of may in the statute could be meant to its an automatic discharge of a mechanics lien. The statute reads, and I'm going to probably butcher this, that XYZ may discharge and it's a list underneath, may discharge automatically or may discharge the mechanics lien. The issue in the case was whether that use of may gave the court discretion that they may discharge it or not, or whether the may was still compulsory in terms of as of the happening of that event, it automatically was discharged. And the court went into an analysis of the grammatical structure of the statute and looked around the term may. They noted the past tense that was used in the language. And ultimately held by looking at the context in which may was used, that no, ultimately there was no discretion. The court couldn't say it wasn't discharged, that it was automatic upon the happening of the event listed in the case. And so my takeaway for this committee is, again, words matter and how we use words matter. and down to commas and periods. And as much as people like to joke and laugh at the lawyers in this committee, when we look at those little things and spend a lot of time on those little things, it legally impacts you at the end of the day. And there, as a buyer or seller, there's good reason we spend a lot of time really going over this language and how much responsibility we have to try to take into account these things up front. Any other comments on that case? Or?
No, I was laughing a couple times through that case, but it's I kept thinking how Brian was going to enjoy that case a lot. You're a title examiner for them.
So that's
what it is.
Only case we have attached to our materials. Not getting into the commission cases. Are there any other cases that somebody else wants to bring up or discuss or has to offer? There being none, I think this is an opportunity where we can each take, and then I would suggest, we can have a clock of 2 minutes or less to state our position, or at least give some informative discussion on the commission issue, maybe where our minds sit. And this isn't meant just to tee it up. This isn't necessarily our firm ideas. This could be just whiteboarding in our heads out loud, just talking about things. Those listening and to this, we're trying to think this out. We're not saying this is how it's going to be. Our opinions with the changing circumstances might change tomorrow, and who knows what's in the headlines, and trying to take into account these rules. So what we're doing here is just trying to whiteboard, trying to get stuff on the table so we can take a closer look, because it's very impractical for us in this meeting to draft a coherent document that, with 13 people sitting around the table. That's tough. So the subcommittee will take back all these comments, all the ones that are received after this meeting, and consider that and coming together with a proposal that this committee will consider at our next meeting. And then we'll have a more fulsome discussion with feedback from the public, license holders, and the subcommittee on it. And so teeing it up with that qualification, do I have a volunteer to go first? Not all. Look at Tony.
Yeah, I think I said everything I wanted to say earlier. I appreciate the time, but I think we want to make sure there's transparent for the public. I want to make sure we stick with our role, though, as well as Purple Lawyer Committee. We're not here to solve litigation matters. We're here to make sure we protect the consumer. And think, like you said, we can't do it all in this one meeting with that much input. We're gonna need to think about it, stew on it, break it down.
So I would envision a clarification document, because what I don't want to have happen in the contract form is for agents to use it as the negotiation necessarily for their commission. There should be separate written agreements. There should be the listing agreement. There should be the buyer rep agreement. There should be those documents in place. And it's not the document that they use for the commission, because that's not what it's about. It's about the consumer protection. It's about, at the end of the day, one quick location where the consumers, all parties to the contract, are very clear on where the monies are coming from. And that's it. And so that's what I envision when I see a simplistic, clarifying, transparent piece that the public can look at and say, okay, makes sense. That's awesome. And there's no ambiguity around it, but not for the agent to use as the contractual agreement in regards to that. It's just simply laying out, this is where all the monies are coming from.
No, I'll reserve comments for a later take.
Fair enough.
I mean, again, I think I very much agree that the point of getting consumer disclosure out there is important. Give them a last chance before they execute a contract to make sure that they've got informed consent going forward with it, and something that is as simple as possible that doesn't eliminate listing or buyer's rep agreements.
My only request is that it would be easy to understand for the title companies. 'Cause we're the last one that gets to.
Lee?
I don't have anything to add. I'm just listening.
Anyone else?
I think that's it.
I said this to a broker earlier this week. One of the silver linings of this whole thing is that buyer agents now will start doing buyer rep agreements. I can't tell you how many times I've talked to buyer agents and I say, well, what does your buyer rep agreement say? And they say, oh, I didn't want to offend the buyer by asking them to sign a buyer rep agreement. But now it's going to be important. And I'm going to echo and elaborate a little bit on the importance of there being one simple document for parties to understand, because the old paradigm of there is the listing agent and the listing agent gets 6% and they share 3% with the buyer's agent or whatever the negotiated percentages are, that's out the window. And there's going to be numerous different ways in which commissions may be addressed. And the consumer had enough problems understanding the old way, and the new way is going to be exponentially more difficult to understand.
I personally think this is an opportunity that we look at, and I want our committee, and I'm personally guided by our statutory directive to reduce controversy, to make it, to simplify, to streamline things, and to really provide a balanced form. I'm a very big believer in everybody's freedom to contract. And I'm concerned about some of the suggestions that are out there in the public that limits choice. I want buyers and sellers to have choice, to make the agreements that they want to make. I want them to have freedom to pay or not to pay a commission, and to who to pay it to. And I think our role as a committee is not, our directive is to protect the consumer in our statutory directive. We're not very clear that we're operating independently under that directive. And I think it's very clear in our discussion here that that's what we're all going after. And so I would want us to keep that in mind and keep that in focus. And where I see this leading is more transparency, more disclosure. Whether we end up with enforceable agreements in our documents or not, the underlying thing is make sure we preserve each side's ability to fully negotiate the deal they want. Don't restrict their ability to say, on their ability to pay or not to pay and who to pay. And to just make sure whether it's enforceable or not, it's clear. And that's not necessarily a simple task, and that will change depending on how all these lawsuits come down, which can be years into the future. So in my view, we'll do our best. We'll try to accommodate it, but I really want to try to keep it simple and that freedom of contract open.
I agree with all of that. The advantage to being on this side of the table is I can validate all of your comments. I don't really have such to add.
Well, and I think that you keep leading us and circling back around to our directive and why we're here and the purpose. And I love the continuation of that tie-in for that.
And I think the transparency is important to the goals and objectives that we have, is for the consumer to have clear and understandable, transparent information available to them. So whatever we do, it has to be transparent. And I'm somewhat frustrated with the fact that I feel like previously there was more transparency, that whatever was happening was going to be published everywhere. And now they're like, whatever's happening can't be published anywhere. And to me, that's not transparent. So I think as much as we can be transparent, I think that's what's better for the consumer. So however that plays out, I'm really, really looking for transparency to protect those that we're charged with protecting.
And I have to commend our leadership. I think the idea of the addendum that Ron came up with and the clarity that John has given us in the direction is what this committee is about. We provide the tools of the trade for the practitioner, and I think this is going to be one of them. And I see the addendum as being that. And to me, it's a disclosure of the understanding of the parties and an invoice, if you will, to the title company, that everybody knows who's paying who. And I think it's just going to make the transaction and the transition that much easier. So I like the direction we're going.
I agree with everybody. I like really being at the end. And the biggest thing is what I equate it to is in the buyer's rep and the listing, we get permission to intermediary. Everybody agrees. But then we do a notice or an amendment at the end when they have the clarity of what we're actually doing. You know, when we actually move into intermediary, we have a notice to intermediary, which is basically just telling both parties, remember what you didn't read over here? Okay, now we're in that position. And I think that's what the amendment will do is we have a buyer's rep agreement, we have a listing agreement, and now here, oh, by the way, this is what everybody has agreed to. And I think that's, I don't know how we want to call it or whatever, but I like the way we're going.
I appreciate everybody's comments on that. And it's not going to be an easy issue to solve, but I think we are all marching in the same direction as a committee to what we need to solve. So with that, now it's to form the subcommittee. And I know there's going to probably be a lot of interest here in joining it. And so I know Lee mentioned she wanted to be a part of it. Let's see, and SJ made the suggestion, and I agree with that Ron definitely should be a part of it.
Definitely. Congratulations.
And so Brian would like to be a part of it. So we have the historical knowledge, we have from the broker side, we have from the lawyer title side. Is there anybody else that would like to?
I'm happy to join.
Me too. Lots of it.
Just careful about, have to
what's
be
our
careful about size on the trigger.
Exactly. So 6 or under that we need to keep. And so now 1, 2, 3, 4, 5. We have 6, so we just filled up.
All right. Can you read them to me again?
Yes. Yeah. So it's Lee, Ron, Brian, Tony, Christy, and Melissa.
I think Estee, was she?
Oh,
She said she was.
SJ can have my spot.
Are you sure?
Yeah.
Okay.
I feel like after this, she's gonna want to be on it, but I feel like after this meeting, we're still gonna have a lot of powwow when the committee comes back. I think there's gonna be a lot of time
For full discussion.
yeah, I can be at the end of the table as it comes back next time.
Strategically picking his seat already.
So we have that in place, and now we can. Our next meeting date that we have on the calendar is July 12th, followed by an October 11th meeting. Are those still good dates? Okay.
John, we have a couple of forms in here that we didn't address, and I just wondered what the intention of that was. We
Which
have
ones?
the backup addendum that staff created into a form, and I know you did mention that we would review it. And then condominium real estate certificate, third party financing, and a new 1031 tax exchange. Are we looking at addressing these all at one time, moving forward through in the year?
I think we've pushed them through as all one package to the commission for review. The backup form, because it was produced so close to the meeting, I really would like everybody to have a chance to go through it to comment on the actual form. My review of it matches our ask of the staff to create the form in terms of the language. And I think as everybody be prepared to talk about that one. The other ones, from my understanding, we went over even the drafts at our past meeting.
Right.
And so at this meeting, I didn't see a need to go back into those. But it will be something when we push them through, we can see if there's any last minute comments.
So I noticed the August 19th date in the corner. So is there, what is the timing process that's going to happen between now and another commission meeting?
So that is just a date that we add. That was assuming if we were going to propose changes at the May meeting, it would be adopted in August. So that's not happening. We'll update that date as we go on.
But we'll meet back in July and we'll walk through those recommendations from that group. And then, like John said, if there's any other comments, you'll probably go through one more review of all the changes if you guys are going to push everything together. But it's a little bit unknown. We had prepared everything with the thought that you might, recommend to propose in May, but it's changed a little bit. So there'll still be time to consider all of the changes that you've already walked through.
Because the next commission's August, right?
Well, yeah, we'll have May and then it'll be August, and it's August 20th, I think.
So there's nothing going to the commission in May?
Correct. We're not pushing it. I was really firmly wanting to do it at this meeting last time. But because of this commission issue and the potential size of the change that will come out of that, I think it's reasonable to push it back. We've had a lot of changes stack up for a while. I really want to get them out there, but I think this overriding issue makes it reasonable to push it all together.
So do you see our goal by the end of the year that there will be new contract forms going out to the license holders?
That is what I see, yes. I would hope we have enough clarity on the commission issue at the next meeting to at least advance something. And if not, I would then push it, divorce the two, and let's push forward the other changes. At least as I see right now, it may change it before next meeting.
Thanks.
I see that of divorcing to be able to push through these other good changes that we have.
Commission sees it in August, then we should be able to pass something by November, right?
Yeah, they would vote on it in November. I mean,
They vote on
okay,
it.
but remember, I will say, it's an up or down vote, right? For broker lawyer committee. So they'll either accept everything or they'll sit back with comments.
Okay.
And I don't anticipate any, I mean, I have no inkling of what will happen there, but that it's not like some will go through or they'll suggest, well, if you just change this and this, then we can put vote to recommend it to be adopted. It will come back to the full table, but I have no idea. I'm just prepping you for that reality that sometimes happens.
I might like to divorce them ahead of time then, sir.
Well, I think that's a form by form issue, correct? Where it's not all or nothing to the whole slate that we're sending up. It's to the actual form by
It
form.
is, but I think some of the changes are often in each form, right?
Mhm.
That's what you're
Practically
doing.
with the commission side. But the addendums theoretically could be separated from that. But, so, I mean, does anybody else have a thought on that and raise a divorce? Are you divorcing now or divorcing at the next meeting?
If we're not prepared to do anything today, which it doesn't appear that we are because we just got the information more recently, fine. But I'm just suggesting that when we send this to the commission, that we not just say, here's everything, if there's going to just be an up or a down vote, that we might say, here's a lot of amendments and then here's another really big deal that needs to be addressed in a separate agenda item.
So you're saying send these in May?
No, not necessarily.
Sending them separate.
And just when we send them, not to clump them all together.
So, and we don't typically, I mean, they are, because each of the forms are tied to a rule, it usually is its own agenda item.
Okay.
It can be.
For just a moment there, I was just having a little panic attack.
Yeah.
It was just all gonna get back.
And that's something maybe you all could give us guidance on at our next meeting, so we can propose it the right
Well,
way.
it will depend on like how many of the changes affect the form.
Yeah.
Which it sounds like what we're discussing would be significant.
And the next thing we have on there is to go over the meeting minutes. I want to offer just a 30-second quick education thing that ties into these rules is if you look at the regulations that govern the real estate industry in Texas or license holders, you have the occupations code, which is statutory. That's what the legislature votes on, that we can't change. The TREC commission can't change. They're operating underneath that legislative action, which is the occupations code, which is also known as the Real Estate Licensing Act. Separately, you have administrative rules, and administrative rules are TREC rules that they vote on, and our contracts are one of the rules, and it's part of that. But you have the occupations code, which is the legislature. You have administrative code, which is the TREC rules that they vote on themselves. And I think having the clarity of the difference is maybe I just geek out on it, but I think it helps people understand the interaction between the two and what we're operating. So when TREC can vote on these rules without having to go back to the legislature, so they can take action at their meetings to adopt these new forms, to make changes. And that's a much quicker process, generally speaking, than if you had to go to the legislature every time to make a change with legislatures that may not know the real estate industry. But that's bleeds into how we have to send forms up and how TREC votes them up or down.
And by attaching the forms to a rule, it allows for that public comment that you receive, which is such an important part, right? So you'll come back and you'll consider all that public comment. And sometimes changes are made as a result of those.
And so with that, we'll move to to approve. We want to go through the minutes.
Sure.
Right now.
I was trying to get rid of some typos real quick before embarrassingly stick them up. Let me know when you want me to move it up, John.
Okay. Let's see, everybody's. Okay. That looks good to me.
If anybody sees any, that I misspelled your names, let me know. I think I was missing one commissioner. Oh, Jason Hartridge?
Realtors is misspelled in item number 2.
Oh, T instead of E.
No.
Item 2,
HART.
last line of
So it'd be
You're on the
HARTTRAB.
Grandma?
Heart grade.
Oh, art. Oh, got it.
Heart.
There
Yeah,
you go.
there you go.
Thank
There you go.
In number 2 there, realtors.
Okay. And you said realtors was misspelled somewhere?
paragraph 2, first line.
Item 2. Oh,
First line at the paragraph number 2.
Up paragraph.
up a paragraph. There we go.
There you go.
I would just like for the notation of the minutes to note that a discussion was had before the Texas Realtors presentation, or at least their number 2, item 1, that I took it first and provided an overview of the current status. I just would like to.
Okay.
It sounds like we just turned it over to Texas Realtors, which I just want to make sure that we.
Okay. Let's see here. What do I just say? What did I just say? Took one item. What don't I just say? Took up the first item for discussion. That'd be sufficient?
Yes. The concern I have there is just somebody reading the sterile document. It looks like the floor is just turned over to Texas Realtors.
Okay.
Instead of being informative in nature.
Okay.
Maybe representatives from Texas.
Thank you. Good catch.
I'm good with all of these if you want to scroll.
Good with those?
Mystic reading it, but I don't see what I would like notice too is the discussion of a possible addendum for there, just so it's one of the options the public sees that we're.
Here's the last one. There we go. Let me just say, consider work? Oh, it's Christie. I was worried about your last name.
You nailed that one.
I frequently about it last name.
I frequently misspell it too, so I drop it.
I guess there should be it.
Love that we have an Oxford comma grade.
I'll wear my t-shirt to that.
Yeah, not only do words matter, but so does punctuation.
And we are at 1:10, right?
It's not 2:34 yet.
That was from last time.
I think, any other changes to the agenda or the minutes? Okay, with that, we'll add in 1:10 as the adjournment time and adjourn the meeting.
Ooh,
I am shocked.
me too.
Who's expecting this to be?
Yeah, on a basis.
I am